record should reflect that we've got a bench conference. My understanding is, Mr. Dukas, you're just coming in and without going into detail that there may be additional charges, you're asking for an adjournment.
That's correct, Your Honor. Just 1 week.
So preliminary examination will be adjourned to, is that the 28th? To October 28th next week, 2025, 9 a.m. That's before me.
Thank you.
And that's also the bond hearing, as well as the exam. His bond will continue as revoked and denied.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jessica Hafner.
Now, Assistant Prosecuting Attorney, on behalf of
On behalf of Ms. Hafner, who's approaching the podium. Ms. Hafner, please take your name for the record.
Jessica Hafner.
Your Honor, today's date and time set for preliminary exam. There was an offer tendered this morning. Ms. Hafner would like some time to consider that offer, as well as
I'm here all day.
we were asking for just an adjournment, Judge. We wouldn't want to put the court under that kind of pressure to have that kind of
It's
quick
no pressure
turnaround.
on me.
We are asking for an adjournment if the court would be so kind.
I have no objection to it, Your Honor. There is a
Of course you don't. Not your docket.
case open on this case.
What?
There is a neglect and abuse case open, so I do have a modification.
Preliminary examination will be adjourned October 28th, 2025, 9 a.m. That's before me.
Thank you, Your Honor. Your Honor,
It's when we want to
there is, I did mention that I do want to do a modification to the bond regarding contact with children. We just would ask that the conditions to seeing the children be based upon case number 25-41 through 47 NA to be consistent with Judge Vandenberg's orders with the CPS case, which is supervised visits upon.
Problem with that is Judge Vandenberg ruled that. I'm just not going to have an issue with it, but I'll need a written order to the court and I'll sign off on it when you stipulate to it. All right. Thank you.
That's good. Thank you, Judge. Thank you, Mr. Dowd.
Continue.
1028.
Court calls case People versus Shaquille's Gully.
That's close for people.
They're just going to be a waiver. Right.
That's last week, today, now.
Here for what, Mr. Hardman?
Your Honor, my understanding, the defendant is entering a plea of guilty, changing his plea to that of guilty on count 1 of the indictment. The state will be dismissing count 2 at this time.
Mr. Wendell, is that accurate?
It is.
All right, Mr. Redkey, they're telling me you're going to change your plea to guilty to 1 count of the indictment. Before I get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, Your Honor.
How old are you?
20.
How far did you go in school?
To be honest with you, I didn't really make it that far in school. But like,
Well, how far did you go?
I'd say 10th grade.
Can you read and write?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you in this case?
Not necessarily.
Well, it's a yes or no question.
No promises in the case. No promises.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation you've received from Mr. Wendell in this case?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor. My test will show that.
Do you take any medication that interferes with your ability to understand what's going on today?
No, Your Honor.
I have in front of me a document that's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, Your Honor.
Did you read it and go over it with your attorney before you signed it?
Yes, Your Honor.
Do you understand that you are pleading guilty to an offense that carries an indefinite sentence?
Indefinite?
Indefinite.
What does indefinite?
Well, that's what I'm trying to find out. That's why I'm going to ask you questions. You honestly answer the questions because I'm trying to find out to make sure that you
Yes.
don't, sir, listen to my question and then answer me honestly. I'm just trying to make sure that you're making a fully understanding what's going on here, okay? Do you understand that you are pleading guilty to an offense that carries what's called an indefinite sentence?
May I ask what does indefinite mean?
I'm going to explain it to you.
Thank
So
you.
you
I'm
don't,
sorry.
you don't understand that. Okay, so what's going to happen is you're going to receive at sentencing, if you're sent to prison, you're going to receive both a minimum term sentence and a maximum term sentence. Do you understand that?
Yes, Your Honor.
Okay. And you understand that the court will select, if you're sent to prison, the court will select between 2 and 8 years as the minimum term sentence. The court's going to select the number. That's the range of the penalty. The maximum penalty is 8 years, a minimum term sentence on this offense. Do you understand that?
Yes, Your Honor.
You're acting like you don't understand what I'm talking about.
I do understand that it can
Okay.
carry 2 to 8 years.
So you understand that once the court selects that number between 2 and 8, the maximum term is going to be automatically calculated to be that number plus 1/2 of that number. So it's a mathematical formula. So if the court selects the number 8, which is the largest number for the minimum term sentence, the maximum term is automatically going to be 8 plus 1/2 of 8, which is 4. So the maximum term would be 12. Do you understand that?
Yes, Your Honor, but may I speak?
No, you may not. Again, if you have questions about what I'm asking you, we're not getting into sentencing today. No one's promised you anything because I've not made a decision on how I'm going to sentence you.
No, I
You understand that?
I appreciate that, and I do understand that.
Mr. Redkey, I understand that you're nervous, but right now is the time for you to listen and try to understand what I'm talking about, okay? If you have a question about what I ask you, that's fine.
I do appreciate you, and yes, Your Honor.
All right. Now, so we've talked about the minimum term, we've talked about the maximum term. You understand that that there's a rebuttable presumption of you being released after you serve your minimum term or the presumptive earned early release date, whichever is earlier.
Yes, Your Honor.
The Department of Corrections may rebut that presumption through an administrative hearing process and thereby maintain your incarceration for reasonable periods of time reasonable periods of duration up to the maximum term, and in this case, that's 12 years. You understand that?
Yes, Your Honor.
All right. Now, the criteria for the Department of Corrections to rebut the presumption and to maintain your incarceration after you serve your minimum term or the presumptive earned early release date, whichever is earlier, include the following. Number 1, during incarceration, you commit a rule infractions that compromise a prison's security, compromise safety of staff or inmates, cause or threaten physical harm to staff or inmates, or you commit a violation of law that was not prosecuted, and any infractions or violations which demonstrate you've not been rehabilitated, or that your behavior demonstrates that you continue to pose a threat to society. Or number 2, regardless of the classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date. Or number 3, at the time of the hearing, you are classified by the Department of Corrections as a security level 3, 4, 5, or higher. If the Department of Corrections rebuts the presumption, the Department of Corrections may maintain your incarceration in a state correctional institution under the sentence after the expiration of the minimum prison term or presumptive earned early release date for an additional reasonable period of incarceration to be determined by the Department of Corrections not to exceed the maximum prison term. Also, the Department of Corrections may maintain your incarceration more than one time up to the maximum term. The Department of Corrections shall release you at the expiration of the maximum term if you've not already been released prior to that time. You are eligible to receive 5 to 15% earned reduction of the minimum prison term credit for exceptional conduct or adjustment to incarceration, but there's no guarantee that the Department of Corrections will request ERMPD for you. There is a presumption the ERMPT would be granted by the trial court, but the trial court may determine to rebut that presumption and not grant that early release. There's also a maximum fine on this case of $20,000. The prison term in this case is not mandatory, but is presumed to be necessary. So do you understand all the maximum penalties involved?
Yes, Your Honor.
In addition to those penalties, you are also subject to a mandatory period of post-release control. Again, if you're sent to prison upon your release, the adult parole authority will supervise you for up to 3 years, but not less than 18 months. If you violate those terms of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
Now, as I've stated, it's not mandatory that you're sent to prison, although presumed to be necessary. The court does have some discretion in granting you community control, or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, Your Honor.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that? Yes?
Yes, Your Honor. Sorry.
Now, the burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
May you repeat yourself, Your Honor? I'm sorry.
The standard of proof is beyond a reasonable doubt.
Yes.
The state must prove beyond a reasonable doubt each and every essential element of each charge from the indictment. Do you understand that?
Yes, Your Honor. Sorry
Now,
about that.
that's right. Now, you could waive your right to a jury trial, but maintain all the other rights we've discussed, and you could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've discussed?
I would say yes, Your Honor.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
That's right. We will not be having a trial. You'll be waiving the rights.
Do you think there should be a trial, in your honest opinion?
No. This is the plea that we've discussed.
Yes, Your Honor.
This is how you want to proceed.
Yes, Your Honor.
Mr. Hardman?
Your Honor, on June 29th of 2024 in Warren County, state of Ohio, the defendant with several other individuals did cause serious physical harm to Joshua Kriasik.
Mr. Wendell, anything on those facts?
No, Your Honor, we will accept those.
Mr. Redkey, did you hear the statement that he read? Did you hear what he said?
Yes, Your Honor.
Do you admit and acknowledge what he said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we just went over.
Yes, Your Honor.
What's your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Mr. Redkey, so I need you to go down to court services. Since you were late this morning, you need to go down there and drug test and schedule your pre-sentence investigation interview. Mr. Hardman, is there anything else?
No, Your Honor.
Mr. Wendell?
Thank you, Judge. I will get a sentence date as well.
All right, very good. Thank you all.
Thank you very
Thank you.
much. Don't forget your gear here. Come on with me. I'm gonna get you that next court date too.
Do you need those papers?
I do not, thank you. I have to make sure you get your.
Thank you.
Yeah.
Never mind. All right, Mr. Gully is here.
I tried to get back there to see, but this is the waiver form. You ever like to have a trial? Waiving it. I accidentally signed up the judge for the court's information. This is going to be a waiver.
Sir, as you're signing that form, you're going to waive your right to a preliminary examination?
Yes, I am. Judge, for the record, Robert J. Kilwell on behalf of Mr. Jacavius Gully.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged was committed when you committed them.
I do.
All right, you understand you'll not have that hearing. You'll proceed to circuit court for further risk.
Yes, I do.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts. Mr.
Judge, we now received the information waiver. It's reading. My client was stand mute.
Defendant ever waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 4th at 1:30 with Judge Simpson.
November 4th, 2025, 1:30, Judge Comfy.
Thank you, Your Honor. Okay, I couldn't see beforehand.
Bond continued.
May I approach the signing to make sure?
Amen. Court does call the case, People versus Juliet Burns.
Good morning, Your Honor. Rob Jekyll on behalf of Ms. Barnes. Juliet, would you state the name for the record?
Juliet Barnes.
Thank you.
Judge, today's time and date for a preliminary exam in this man.
It's Mr. Overwater's case, or I'm stating it, I'm not sure.
He said that was going to be a dismissal.
All right, then I believe we are unable to proceed.
I would ask this matter be dismissed, Your Honor.
People being unable to proceed. This case is dismissed. That's without prejudice.
Thank you, Your Honor.
That means if they ever want to, could, because
Court calls the case, People versus Kevin Claypool.
That's counsel for the people.
Good morning, Your Honor. Rob Jekyll on behalf of Mr. Claypool. Mr. Claypool, would you state your name for the record? Kevin Mark Claypool.
Thank you.
Dismissal.
And Your Honor, I believe at this time people are unable to proceed.
I was informed by Mr. Overwater that was.
Where is he?
Wait, can you see the pants on there, please? You look for Kevin. Yes.
Assistant prosecuting attorney for the people. Sorry about that, Your Honor.
Wait, what are we doing on this?
People are not ready to proceed. I would ask this matter be dismissed, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Good for you, okay?
Thank you, sir. Court calls case, People versus Michelle Harrison.
Asking counsel for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mrs. Harrison, who's way to the podium, Judge.
Hey, ma'am.
Michelle Harrison.
Great.
Yes, Your Honor, I've gone over her absolute right to an exam with Ms. Harrison. She has executed the form waiving that exam. She wishes to waive this preliminary exam and be bound over.
Is that correct?
Yes, sir.
You understand the preliminary examinations of proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all 4 counts. Mr. Gaddy.
Your Honor, in terms of arraignment on the information, we waive reading, stand mute, acknowledge receipt of that information.
Defendant every way form of reading standing mute. Court will enter a not guilty plea. Pretrial will be set for December 15th, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Thank you.
Bond will.
Negative photos.
Thank you, Your Honor.
Thank you.
The court does call the cases of the people versus Robert Gallant or Gallant.
Asking counsel for the people.
And Alex Warren Green on behalf of Ms. Gallant in the case ending 5713.
Interrupt you, on behalf of Ms. Gallant, on 5612. Today's time and date for exam on both matters.
That's correct, Your Honor. And as to both matters, people are not able to proceed.
We would ask that these matters be dismissed, Your Honor.
People being unable to proceed, these cases are dismissed. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case people versus Dexter Hubbard.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Ben Benowitz on behalf of Mr. Hubbard, who joins me at the podium now. Would you please state your name for the record, Mr. Hubbard?
Right, what are we doing?
Yeah, the people are asking to adjourn the preliminary examination. I was informed this morning by my victim advocate that the victim's wife went into labor this morning. So he would have been here. He has been very motivated to proceed with this, but under the circumstances.
Just when labor, we got time.
I don't know how.
Okay, never mind, never mind.
That's not my area of expertise.
Your Honor, I've explained to my client that this would be reissued. If the court was to dismiss it, he would be rearrested and probably spend the night in jail. So we're agreeable to one adjournment. We'd ask the court to dismiss it next time if this complaining witness doesn't show up.
Absent, God forbid any complications, and yeah, I'll certainly consider that, but. Preliminary examination, October 28th. Okay, 2025, that's before me.
October 28th.
Yeah, 1 week. I mean, how long is she gonna be in labor?
I don't expect she's going to be in labor that long, but I would ask for, with the Mr. Hubbard being out of custody, I would ask for a slightly longer date. Just, I don't know.
This can go to, I know what my date is. This can also go to Washington, so. What's Washington's next one? Oh, this is our guy. Oh. So. No, never mind. November 25th. Thank you for reminding me of that. In 2025, that's at noon.
Yes.
12 noon.
November 25th. Okay.
Bond continues.
Thank you.
Thank you.
Thank you. Court does call the people versus Joseph Smith.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Ben Benowitz for the defense.
Okay. We started.
Mr. Smith, would you please state your name for the record?
Joseph Smith.
All right. I have before me 2 plea forms. Is that what we're doing?
Yes, Your Honor.
All right. So I think on one of these, we started the exam, but he's waiving his right to continue to exam on this.
Yes. That's correct, Your Honor.
Is that right, counsel?
Yes, that's correct.
I have before me the two plea forms. In the case ending in 5618, defendant is going to be pleading guilty to count 2 and 3, count 2 being a larceny, 200 to 1,000 to 1 year offense, and count 3 false pretenses, 200 to 1,000, also a 1 year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding in that case. In the other case, ending in 5720, the defendant is going to be pleading guilty to the charge of larceny, 200 to 1,000, 1 year offense. That's count 7, count 8, false pretenses, 200 to 1,000, also a 1 year offense. Upon his plea to that charge, counts 1 through 6 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand and say your name.
Justice Smith. All right. Sir, it is this court's understanding that you are going to be pleading guilty to 4 misdemeanor charges. Is that your understanding?
Yes, sir.
All right. 2 of those counts are larceny, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. It's also this court's understanding that you're going to be pleading guilty to 2 charges of false pretenses, 200 to 1,000. Those are also misdemeanors carrying a maximum penalty of up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than 2,000, that would become the maximum fine. Do you understand that?
Yes, sir.
All right. Understanding all of that, you still do wish to plead guilty?
Yes, sir.
I do also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and in these matters, you'd be sentenced before Judge Valvo in the 15th District Court. Do you understand that, sir?
Yes, sir.
To the charge of false pretenses, or I'm sorry, to the charge of larceny, 200 to 1,000, occurring between the dates of November 18th, 2024 and November 22nd, 2024. How do you plead?
Guilty.
To the charge of false pretenses, 200 to 1,000, occurring between those same dates. How do you plead?
Guilty.
To the charge of larceny, 200 to 1,000, occurring between the dates of November 9th and November 15th, 2024. How do you plead?
Guilty.
To false pretenses, 200 to 1,000, occurring between those same dates. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
You have any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or force you?
No, sir.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty?
Yes, sir.
All right, starting with the case 5618. Between the dates of November 18th, 2024 and November 22nd, 2024, location of 1939 Jackson Avenue in the city of Ann Arbor, Washtenaw County, state of Michigan. What do you do to make you guilty?
He's just asking me which one of the 2 cases this is, Your Honor. I'm showing him the police report to jog his memory. And I think.
Took and used the debit card, Your Honor.
I'm sorry?
Took and used the debit card.
Okay, you took a debit card from,
Did that debit card belong to Nora Hartong?
It did?
Ms. Hartung.
All right. Did you have authority to use that?
No, Your Honor.
All right. And you took it without her permission?
Yes, sir.
All right. And then what'd you try to do with that card?
Used it for multiple purchases.
All right. And so you tried to do that and use that card?
Yes.
Right? And at no point that you did that, did you have authority to use it?
Correct, Your Honor.
All right. And in using it, did you obtain property, goods, or services in excess of $200?
Yes, Your Honor.
All right. Going to the next case, between the dates of November 9th, 2024 and November 15th, 2024, at that same location of 1939 Jackson Avenue, what'd you do that makes you think guilty of?
Obtained a credit card and used it.
Okay. So same type of circumstance?
Yes, Your Honor.
All right. And who did that card belong to? Do you know?
Thomas Novar.
Okay. Did you have their permission to use that?
No,
card
sir.
Or have that card in your possession?
No, sir.
All right. And when you used it, did you obtain goods or services in excess of $200?
Yes, sir.
All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rule, the court would no longer be bound by any sentence or evaluation or recommendation. You understand that?
Yes, sir.
And you also understand you would not be entitled to withdraw your plea.
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None that I'm aware of.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
No, Your Honor, sorry. I'm satisfied, Your Honor.
Defense believes the court complied with the court rule as well.
All right. Court will accept the defendant's plea of guilty to counts 2 and 3 in the case ending in 5618 and to count 7 and 8 in the case ending in 5720. Pre-sentence evaluation and recommendation is ordered at 15th District Court. Sentencing in this matter will be
November 18th at 9 a.m.
November 18th, 2025, 9 a.m. before Judge Rallo. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case People versus Jimmy Murray.
Lieutenant Overwater, Assistant Attorney for the People.
Good morning, I'm Roderick Green, P33837, on behalf of Mr. Jimmy Murray, who stands to my right. Good morning.
Good morning, sir. Your name?
Jimmy Murray.
You're waiving, he's waiving preliminary examination.
Yes, Your Honor.
Sir, is that correct?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do, Your Honor. There is, however, an offer I'd like to put on the record.
Go ahead.
In exchange for this waiver, Mr. Murray in circuit court may plead guilty to count 1 and count 3. The people will agree to dismiss count 2. Additionally, the people were prepared to file an amended information this morning, adding count 4, felon in possession of a firearm. We will obviously not be filing that or adding that charge. The people further agree that Mr. Murray can be sentenced to a term of probation and that on count 3, he can be sentenced under Rule 7411, which he is eligible.
That is correct, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts. You acknowledge receipt of the information waiver treaty?
I do, Your Honor.
All right. Your client stands muted this time.
Beg pardon?
Your client stands mute at this time?
Yes, Your Honor.
All right. Defendant having waived formal reading, standing mute to all three counts, court will enter a not guilty plea. Pretrial will be set for
December 17th at 1:30 with Judge Conley.
December 17th, 2025, 1:30 before Judge Conley.
Thank you very much, Your Honor.
Thank you. Bond will continue. Always a pleasure seeing you, Mr. Green. Why? There's bunches of them down there.
I know.
You mean that's all?
Wow.
You know what's gonna happen if I get bored?
Shipment is ready.
Are you ready on anything else?
Shipment is ready, Your Honor. And whenever Mr. Gilles comes back from Richmond, I'm ready on both of those now.
Court does call the case, People versus Derek Shipman.
That's called people.
Michael Gaddy, Assistant Public Defender with Mr. Shipman, who's approaching. He's on my right. State your name, Mr. Shipman.
Derek Shipman.
Thank you.
Your Honor, I believe that I spoke with Mr. Shipman yesterday. I believe that he has retained Sam Bernstein, who can't be here today. I did speak with Ms. Landy, who was okay with an adjournment of the exam so that he can have Mr. Bernstein represent him.
I do think Mr. Bernstein will be here later this morning, but he has not received any discovery, so I'm sure he would not be able to go to exam today, Your Honor.
Preliminary examination will be set October 28th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Court does call the case, People versus Dion Richmond.
That's calls for the people.
Defender Chelsea Vergils on behalf of Dion Richmond, who is in custody at the Columbiana County Jail in Lisbon.
Where?
The Columbiana County Jail.
I never heard of it either, Your Honor.
It's near Cleveland.
You're just pulling our leg. Where is that?
Lisbon, Ohio.
Oh. She doesn't know.
It's real. I Googled
It's real.
Googled it. Yeah.
I Googled it. It's real. Of course. You're of the generation. I Googled it. It's gotta be real.
But someone from our office did call yesterday and confirm that he is there.
At the number Google gave you? Never mind.
Your Honor, he is not present as previously stated. This is a 7-year-old case. So at this time, I'm just gonna go ahead and represent that I don't believe I'll be able to proceed at any time. So I'll let the case.
I would move to dismiss.
All right, in absentia, I don't know harm to the defendant. People being unable to proceed at this time. This case is dismissed. That's without prejudice. All right.
Thank you, Your Honor.
Thank you. Now, what she has taught every defense attorney has come up a jail my clients have. Anybody else ready? Besides me? That is a no.
We will be ready on Mr. Russell shortly. I expect Ms. Vergils has a little paperwork to do.
Got it.
That matter will be a waiver, the resolution in circuit court.
Got it. And you said Ms. Gilles had that?
Yes, Your Honor.
Walked
I
out.
might be speaking to him right now.
And I have one matter on Mr. Bernstein, who did inform myself and Ms. Wiley that he was gonna be running a little late this morning.
All right. So we'll put that. And then Mr. Warren Green, what do you have and are you ready?
Your Honor, I have Mr. Bradford. I'm waiting on Hannah.
Okay, all right. Well, put that to this. I'll tell her what happened with that one. Mr. Goldstein?
Your Honor, I'm in the same situation as Mr. Green. I'm with Ms. Tanner and she indicated she's not quite ready.
Did she yell when she said it? Never mind. All right.
So I have another one that's missing.
Reverend Green, Mr. Green, do you have something else, sir?
I know, Your Honor.
Huh?
No.
You're just hanging around with us?
Big pardon?
It's okay. No, you bring a lot of peace to the room. I'm.
Thank you, Your Honor.
Yes, you may. All right. I'm
Act, we are submitting our impact statement in this case. The physical damage to property at Gibraltar Self-Storage Unit 3031, 129, 2640 West, 400 West Jefferson has a proposed repair estimate of $6,250. This does not include disposal of damaged parts, a minimal estimate to be $300. So this will be the damage to the partition between units. 2 units were able to be rented due to the damage, creating a loss of income of $110 a month, each 9 months of each times 9 months of 1980. Plus, Mr. Mohammed, your name? You guys worked this out for $1,000 in restitution, and I hate to tell you, they're asking for a lot of money. Did you confer with the victims? They're in the courtroom, 2 of them.
So my understanding is, so I received a phone call from the defense attorney that's on the co-defendant's case. And he actually informed me that there was a restitution amount of $6,000, somewhere in that range. And I received this phone call prior to me walking into the courtroom. And he indicated that full restitution was made on that case. So I actually think that we should adjourn today's hearing so we can decipher exactly what happened in the co-defendant's case, because.
Come on up here, gentlemen.
Yes, keep going.
Your name, sir?
Yes, from Vitaly.
Your name, sir?
Mark Gardner.
Where is Chris Lamphere?
He couldn't be here today. He has a safe answer.
Okay, we don't need to talk about that. I'm sorry about that, though.
Okay.
We got a dilemma because you guys agreed to this $1,000 in restitution. I got somebody here claiming $6,250 plus disposal $300, economic loss $1,980 plus $220 a month.
Yes, and Your Honor, I think that's due to there being a co-defendant. There's other cases associated with this, so there.
How many other co-defendants are
I
there?
think there was 2 other co-defendants. 6 individuals were at the scenes.
I saw that.
Leading the charge.
Including your client. Well, I get it, but
And Judge, just based
have the other 2 cases been adjudicated?
I don't know about the other 2. I know one has, and that's who called me today, this morning, as I was walking into the court, the defense attorney on one of those other cases, and he indicated that full restitution was paid.
By who?
By his client. And that's why I'm requesting an adjournment to come.
I understand. Did you guys receive full restitution?
We haven't received anything yet.
And it might just be with the court. That's why I'd like to just figure out what happened.
And I understand, but yeah.
To speak to the co-defendant's counsel,
Who is it?
it's Ronald Blunt. He's in juvenile court right now, the 3rd Circuit. So how that works is, from what he told me, the prosecutor would only give him a deal in juvenile court if his client paid full restitution. I told him that we owed $1,000. I told him we provided proof that we paid that $1,000. So this prosecutor will subtract that $1,000 from whatever he owed. It's my understanding that he's going around and trying to collect money from all the individuals.
Who is?
The attorney for co-defendants. So,
Do you guys have insurance? Take your hat off, sir. Do you guys have insurance?
we do have insurance, yes.
What is your deductible?
$5,000.
Yeah. I get it. All right. I don't have a problem adjourning this. I hate to make counsel come back, but I think we have to. I'm sorry. I don't,
Is the restitution going to go up? Because that's made for our deal.
well, you'll let me worry about that, okay? I think the bottom line, though, is, I don't mean to be critical, but before you set figures for restitution,
The judge, this came from the deputy chief.
I don't care who it came from. I don't care if it came from Kim Worthy. It doesn't matter to me. The point is, these guys are now submitting a claim for somewhere in the neighborhood of about $8,000. And you've got 3 defendants and you've got one that's pled apparently, and one's in juvenile. And, now it creates problems because they're going to have the right, if somebody's going to seek restitution over and above that, I'm going to allow them to withdraw their plea because that was really part and parcel of the agreement. Whereas if it was just restitution to be determined, that's one thing. I'm not criticizing you. I understand a lot more than you think. Let's adjourn this. How long do you think we need to adjourn this?
1 week.
You sure?
Yes.
You don't want to go a couple more weeks, see what happens with the third defendant if he comes in?
We'll request 2 weeks.
All right, let's go, Lisa, to
November 4th at 8:30.
November the 4th at 8:30 in the morning. Okay, gentlemen? I mean, now that I made you come here in person once, I think, right? I don't mind as long as your client's in court with you, but he's going to have, does he have a problem? Do you have a problem? Let me start with you. He was shaking his head yes when I said $1,000 that he seemingly indicated he brought that with him for restitution. How about if I said $100,000 cash bond, assuming he has it? And then we can put it into his name, Lisa, and then that will cover his aspect of the restitution. Fair enough?
Yeah.
Okay, so let's do that. Adjourn sentence November 4th. Defense attorney, defendant can appear by Zoom as long as you're in the same room, counsel, okay? And then, gentlemen, I would still like you to come. I'm going to give you a notice to show up here November 4th at 8:30. I see you have something in your hand, Mr. Pietro, right?
Yes, I just have the court paperwork, and then I have the estimate from the company that originally installed the buildings to repair it, and my impact statement.
Was that all attached here? I think it was, right? So I have that here.
Yeah, you have it.
Okay, good enough. And if you'd like to take a look at it, you're free to do so, counsel. And I'm talking to you, Mr. Muhammad, as are you,
Yes.
Mr. Muji. Okay,
Want to speak to the victims, without due consent. Have you guys gone to the juvenile court at all? Did you notify the
The juvenile courts today was supposed to be today also. And I originally tried to get one of them changed, and you can't change any of them. It just so happened both of them are at the same day at the same time.
well, maybe you can still go down there.
Absolutely.
Okay, guys, thank you very much, but go down the hall, get your notice. Thank you. Thanks, Mr. Muhammad. Kenneth Scott Thebo? Kenneth Scott Thebo here. People against Jerry Bussell. Jerry Lynn Bussell, 24B1463028. Your name, sir?
Jerry Bussell.
You have $38 you owe.
When all this started, it was you that decided the case of probably about a year ago. I've been paying, I'm in every court, if you actually remember, every court down the river. I have a more than.
So what do you want to do?
Well, I want to see if I can pay it on the first when
Not a problem.
I probably, I was gonna ask
The first
of next month.
Yeah.
So I was gonna see, I've been paying downriver, I've been paying everybody.
You don't have to worry about it. We don't need to talk about this. That's fair enough. You came in and talked to me.
The problem is, sir, I got another ticket on my birthday. I just turned 66.
What did you get a ticket for?
I'm gonna explain it to you.
Well, I don't need that. I don't want to know about it, sir. It's not before me. Where'd you get it?
In Flat Rock.
Well, I can't.
You did it before. You was the one.
I'm not going to talk about the ticket without the ticket in front of me. I can't.
He requested a hearing for that one, Judge. It's just pending. We already told him that.
Hearing going on that one.
Yeah, but
I'm not.
It's going to be a different judge. That's why I remember you, and I think you should remember me because I have a big mouth. Remember?
No,
maybe not.
I get a lot of people in here with big. I'm just kidding.
But anyway, sir, on my birthday.
Listen to me. Listen.
Okay.
there's no reason for us to talk about this. I don't want to, you don't get me. She's nicer than I am. Time to pay extended. Time to pay is extended until November the 3rd, okay?
Okay.
And if you need more time, you call the court, we'll go on Zoom, all right? And I'll be glad to give you an extension. Have a good day. Good luck. Thanks. Priority Waste LLC, 25S 026896. Good morning, Ms. Trombley. Your appearance?
Good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
Wow, you got one dismissed?
I did.
What'd you have to do that?
You know.
It's a defective equipment and they did everything, right?
Correct.
Case dismissed, motion of the prosecutor. All right. Now I have another one here. I was going to say it'd be silly for you and Mr. Dillon to both show up, right? You're in the same office, right? Okay.
Yes, exactly.
Priority Waste LLC, 25SO244, 54A and B. Okay. Your name?
Elizabeth Tremblay appearing on behalf of Priority Waste. And Your Honor, we requested an adjournment on that one for 2 weeks.
Okay. Good enough. Lisa, what are we doing? November 4th at 8:30?
Yes.
All right. November 4th at 8:30. We'll see you here. Okay.
Perfect.
Have a good day. Thank
There's
you.
one more, Your Honor.
Oh, boy, there is, isn't there? Okay. I'm sorry.
It's okay.
Priority Waste LLC, 25SO24455A, B.
Elizabeth Tremblay.
Wait a minute, let me see. I don't know if I have one or two here. What do I have? I have an A and a B file. My
A and B,
apologies. Go ahead.
Elizabeth Tremblay appearing on behalf of Priority Waste, Your Honor.
All right. He's going to waive the fines on the spillage. Does that mean they're pleading responsible? It sounds like it.
Yes, and to the overweight with a reduced fine of totaling 1,900.
All right. And you're authorized to enter those pleas on behalf of the company?
Yes, Your Honor.
On the overweight file, file A. Responsible or not responsible to overweight?
Responsible.
And to the charge of spill load, responsible or not responsible?
Responsible, Your Honor.
All right, so I'm going to accept both pleas. Actually, the spill load is a misdemeanor.
That's what I thought, Your Honor, and
Let me talk. Get
they
in
both
here.
said it wasn't. So that's why I was confused.
Spill load's a misdemeanor.
That was what I
Who's
thought.
they? Call me, Jim.
Mohammed and Sergeant Roper.
Well,
If that's the case, Your Honor,
let me see what I can do. I've got him coming in here, okay?
Thank you, Your Honor.
No problem. So on the overweight, I'm accepting, well, let me see. Get hold of him.
I think his assistant answered the phone and I told her that he needed, and then she said, okay.
Well. Does he know I'm waiting for him or? He doesn't have a problem with waiving the fines and costs on the spill load, whether it's they just wrote it's spillage, and I don't have the statute right in front of me, which is a little different than and it looks like he marked in between civil infraction and misdemeanor.
Yeah, and Your Honor, I would want to get the misdemeanor dismissed. That was my
I got
issue.
I got it. Is he in there? Let me forget it.
At the prosecutor's office.
Listen, is Mr. Mohammed in there? I need him, please. This is Judge McNally.
Yeah, I'll let him know right now.
Thank you. Okay. All right. Your name?
Good morning, Your Honor. Mohammed on behalf of the people.
Listen, he wrote this as spillage. They put it down in misdemeanor jacket. Spill load is a misdemeanor. I know that. He wrote it as spillage. He seemed to check in between the civil infraction and misdemeanor on here. Is he in there? Is there a different charge? Civil infraction spillage?
So there is a different charge that I can write it up for. My understanding based off of the representation by the sergeant that was in the room with me is it was a civil infraction.
Where is he? They can't wait for 5 minutes, huh?
It's about 5 minutes. I can give him a call and try and identify them.
Here, I just hate to make this lawyer wait. You're not. Yeah.
I'm not disputing that it be a civil infraction because.
Yeah, but
Sergeant Roper, who was present and he confirmed it was a civil infraction. And the way it's touched mark is it appears it could have been a civil infraction because it's.
They set it up in a misdemeanor jacket because spill load is a misdemeanor. There might be a likable.
There is a similar offense under the civil infraction.
Your Honor, since we're waiving fines and costs on it, would the court be opposed to just dismissing that count?
I can't do it on my own. Do you ever?
Make an amendment to make it reflect a civil infraction.
You already did that. And you said waive fines and costs.
Correct.
Why don't you want to just dismiss?
Well, Judge, I don't know if I have that much discretion. I have discretion to.
What are they doing out there? They're telling you what to do. They give you it reminds me of a playbook from the NFL or something. Right?
Yeah.
I mean, this is you do what you got to do, but I don't want to have to wait for an officer. Do whatever you got to do. I'm handing this back. It doesn't.
We can adjourn this, Your Honor, for the November 4th for the same date as the other one because Sergeant Roper's on that file as well. And I guess we can just go through it then if that's easier. So, because I know he did leave.
I'll do that.
Okay.
It'd be nice if they would wait just until the case is called.
Yes.
That's boy, things have changed, huh? I mean, you don't know that because you were 2 when I started here, probably, if that. But I'm just saying. It seems to me if your office gives you discretion to waive fines and costs, they might want to give you discretion on this to dismiss, but that's not my. I'll just adjourn it to 11/4 at 8:30, Ms. Trombley, okay?
Thank you, Your Honor. I appreciate it.
Thanks.
Have a good day.
Thank you. All right. So at least I just wrote on one of the jackets there to adjourn thing. Witz, Nicholas Gray Witz, 25D237026. Your name, sir?
Nicholas Witz.
You're charged with trespassing with an ORV without written consent, it says. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
I think I need one.
On September, so you waive your right to a lawyer?
I don't really know nothing about.
It's up to you, sir. Whatever you want. If you want me to give you a lawyer, I will. If you don't, I'll go ahead and arraign you and let you go talk to the prosecutor.
I had to speak to a lawyer.
Okay. We'll set you up with a lawyer, and then either way, you'll come back in front of me after your lawyers talk to the prosecutor, okay? Baxter, Michael Xavier Baxter. 25 X457711 A and B. Your name, sir?
Michael Baxter.
How much do you have today, sir?
I haven't had any money.
Where do you work?
Sorry?
Where do you work?
For Woodhaven, but I've been on fitness for security leave for 2 months, and now I'm being sent to residential mental health therapy tomorrow morning.
Okay. Okay, so you owe 265 and 215, so you need time to pay you're coming in here for, right?
Yeah, I'm gonna be gone 30 days. And lock up residential.
Okay, how much time do you think you need here?
Probably to the 1st of December.
Can you pay it all by then, or do you need?
I'll probably have to do payment plan. I've been out of work for 2 months.
All right. All right.
Apologize.
You don't have to apologize. I'm gonna let you do 50 a week beginning December 1. We will start that on the A file. And then you're gonna pay 50 per week on file B after you've paid the 50 per week and completed your payment on file A. Okay?
Yeah.
So she's gonna give you a printout down the hall. And if you ever don't have the money on any one of the due dates, just call the court. We'll go on Zoom, or you can walk in here on or before the due date, and I'll be happy to give you an extension. I don't really care how many times we have to do that, okay?
I appreciate that.
I wish you well. Good luck. Thank you.
Do I pay online or do I come and pay?
You can do either one. There is a minor fee if you pay online. What is that, Lisa? About $4 on a $50?
$5.
$5. All right, good luck. Thank you. Derek Wayne Flamont Jr.
I'm sorry, where do I go?
You're free to go. Go right down the hall and they'll give you a printout to the cashier window. Derek Wayne Flamont Jr., 25W839-264. Your name, sir?
Derek, mine.
All right. You're charged with unlawful transportation of marijuana, and you have the right to an attorney. I'll be happy to provide you with one at public expense. Would you like one?
Yes, sir.
Okay. We're going to set you up with a lawyer. Just be patient. They have a lot going. As soon as they come in, I will be happy to, as soon as they get a chance to talk to you, they will. And then either way, you're coming back in front of me with your lawyer. Okay? Best of luck. Kenneth Scott Thebo, 25I-722-550.
Good morning,
Mr.
Judge.
Perlman.
Good morning, Judge. Jeff Perlman on behalf of Mr. DeBow.
Mr. Thibault, your name, sir? Where is he? Is he in your office?
No, I think actually he came there in person, so he may be in the hallway.
Why do they go in the hallway? I don't know why they go in the hallway anymore. Why do I have to? It's like I say all the time, it's like going to a Tiger game and staying in the parking lot. It's ridiculous.
Exactly.
What are they going in? I gotta drag him up. I need a Kenneth Thebo in here, please. He's supposedly in the hallway.
Okay.
Thanks. Just give me 1 second. Feel like I need to hire private investigators to find these people and bring them into court. This is ridiculous.
He just called me. Let me. Yeah.
The opportunity to review guys to, and you just, come on.
He didn't know his attorney staff that we were waiting for him.
He's online. You just, come on. You guys got, send these guys, tell these guys to get into the court. Good morning, counsel. How are you?
Good morning, Judge. Jeff Perlman on behalf of Mr. Debo.
Your name? So he pled to, he was charged with CCW. Prosecutor reduced it to improper transportation of a firearm, which is a 90-day misdemeanor. He was referred for a pre-sentence report. Have you had the opportunity to review the report with him? And are there any material additions, corrections, or deletions?
Yes, I have. There are no corrections, deletions.
Anything you'd like to say on his behalf? Any objection to the recommendation?
Well, we're asking that that he is eligible for HIDA. We're asking that the court incorporate HIDA. He is he's working. He has no criminal record. He has a strong foundation and strong family support. This is obviously a mistake that he took responsibility for, and we're asking that the court adopt HIDA. And the,
you talk to the prosecutor about that? They don't want to get involved in these things anymore, huh?
Yeah. I mean, so, it's my understanding that the court has discretion to offer HIDA.
Does he have a prior criminal record?
No. Let me see. I don't believe so. Yeah. No criminal record.
What day was this? How old was he when the offense occurred?
Kenneth, how old were you when the offense occurred?
25.
25.
Okay, so this is what I'm talking about. Did you talk to the prosecutor about this?
I did. Let me see. He did respond that they will not plea, or they wouldn't extend a misdemeanor plea under HIDA. However,
well then,
but it's my understanding
they have consent when when this is. I'll read it to you. That's why I pulled it out. If an individual pleads guilty to a criminal offense committed on or after the individual's 17th birthday, but before his or her 24th birthday, and that does not appear to be the case here, then the court of record, without having jurisdiction, the criminal offense may, without entering a judgment of conviction and with the consent of that individual, consider and assign that individual to the status of youthful trainee if the offense was committed on or after the individual's 21st birthday, but before his 24th birthday. And that wasn't even the case here. He's well beyond the you were born in October of 99, right?
Yes, sir.
So I don't know where you guys were talking about Heidi's.
Well,
counsel,
they would
this isn't even a close call. It's not even a close. I need their consent, the prosecutor's consent, after you can do it. Jeez, how do I say it?
I understand. After they're 25. If they're
I
older
can't do it, is the bottom line. Not
Right.
without their consent, and he's too old to begin with. So I cannot do that under item.
Okay.
They complicate things because they should have just told you that, but that's neither here nor there. What else do you want to say?
I'm just asking the court be as lenient as possible.
Sir, anything you would like to say?
Sure.
Okay, so you understand you can't have you can't have a concealed weapon when you don't have a CPL to begin with, right?
Yes, sir.
And there was an agreement that he was going to forfeit the firearm, correct?
Correct.
And all ammo in his possession. To Grosio Police Department. So you're going to need proof of that when you do that. You understand me?
Oh.
12 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to attend the handgun prevention program with New Frontier. You're not to possess any firearms or other dangerous weapons. You're to obtain employment and maintain employment. You're to forfeit the firearm in question and all ammunition in your possession to the Grosio Police Department within 2 days. So no later than Thursday, I want you to do that. Do you understand the sentence so far?
Yes, sir.
All right. You're to pay fines in the amount of $100, costs in the amount of $150, $75 victim's rights fee, $50 justice assessment. That's $375. Screening fee $60 for $435 plus your probation fees of $240 for $675. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
All right. All right. Can you pay all of this?
Yes, sir.
All right. So you can go ahead and you may be eligible for early discharge. You do everything. There's no violations within the preceding 90 days. In 6 months, you can come in here and apply for early discharge. You understand everything?
Yes.
So you go down the hall, you'll make your payment, and you'll go over to probation where you'll meet with them. If you violate, again, you could get 90 days. You understand that?
Yes, sir.
Anything else, Mr. Perlman?
Not at this time, Judge. Thank you. Kenneth, give me a call when you
Thank you.
leave the court. Thank you.
Anthony Edwin, you're all set. Go down the hall and then to probation. Anthony Edwin Pazianza, 25M602310. I do not still have Trooper Martin here, correct, Lisa?
Oh, not on Zoom.
Come up to the podium, sir. How you doing?
Oh, yeah.
Your name?
Anthony Edwin Castillo.
The officer failed to appear. Case dismissed. I gave him 15 minutes. It's 9:27 or thereabouts, 9:28. Case was scheduled for 9. Case dismissed. Good luck to you. Thank you. Rodney Shaw Tuttle. Now, 25B701485.
Morning, Your Honor. Attorney John Freeman on behalf of Mr. Tuttle, who appears via Zoom, and we appreciate the opportunity to do that.
Mr. Tuttle, your name?
Rodney Tuttle.
I mean, I can adjourn I'll adjourn the PCC to the 28th and then the 4th for you. If you're available both days. I don't want to adjourn the PCC to the 4th and then have it on, I believe the following week, I could be wrong, is Veterans Day, right, Lisa, on the 11th?
Yes, correct. The Veterans Day is the 11th.
So I can do that. I'll do that for you, counsel, if you're prepared to be here on the 4th and the 28th of October.
Your Honor, I am asking you for a little bit of a grace in terms of a little bit more time. I just received the discovery material. I think that there's going to be a good chance of being able to resolve the case that keeps it in the district court without an exam. There is
I don't have a problem with that, but I'm just not going to take it all the way. I'm sorry, I'm not taking it all the way to the 18th. I'm just not going to do it. You guys can talk in the next week. How many pages of discovery you have?
It's not, there's about 22 pages, but there's an awful lot of body worn camera footage. And my client is now resigning.
Are you retained on this?
Yes, sir.
And you have to tell your mother, your client's mother, not to write me letters like this, you understand? I mean, she can't be writing me letters. She directed it to Judge Hessen, but
I was unaware that anybody had contacted the court, and I will be sure to make sure that.
look, I'm gonna just do 1 week each way. I'll do that for you. If you need more time, you can ask for it. I doubt I'm gonna go with it. I don't want to, I only have state docket for 4 months. I'll start to get all backed up, and that I'm not gonna do. So if you think you can make it next week and on the 4th in person, I'll be glad to do that.
Your Honor, may we do next week via Zoom?
Yes.
Is that possible?
Yeah, and we'll set a time for you. Mr. Tuttle, your lawyer wants me to adjourn it. I'm willing to adjourn the case. You have the right to a probable cause conference within 14 days of the date of the arraignment. If I adjourn the PCC, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
I do.
Do you waive that right?
I don't know if I should or if I shouldn't.
Yeah, you should, Rodney.
Okay, then I waive it.
You sure?
That's what my lawyer told me to do, correct?
Yeah.
I don't know. That's up to you guys. I don't want you to do anything.
Your Honor, we've talked about this, so I'm comfortable.
I know, but if he doesn't want to waive, it's no skin off of my neck. I could care less. If you want us to go to your exam next week, that's fine with me.
Whatever my lawyer tells me to do is what I'm going to do.
Oh, that's not good enough for me. Listen to me. If I adjourn this, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
I do.
He wants me to adjourn it. I don't want to adjourn it. He wants me to adjourn it. If I adjourn it, if I grant his request, that means the probable cause conference will not take place within 14 days of the date of the arraignment. And also, do you understand that?
Yes.
Do you wish to waive that right or not?
Yes.
Anybody force you to do that?
No.
All right, I'll accept the waiver. We're going to do the exam on November the 4th at 10:30, and I'm going to do the PCC next week, and I'll work with you on the time. What time? 8:30?
Your Honor, I have a medical appointment at 8:30. Can we do it late in the morning, please?
Will you be done by 10:30?
I expect I would be, yes.
Okay, so we'll do them both at 10:30, okay? October 28th PCC, that'll be by Zoom. And then the exam will be November 4th at 10:30, okay? And I'll see you here then. Anything else, Mr. Freeman?
No, thank you.
Have a good day. Good luck, Mr.
You
Tuttle.
too.
Thank you.
People against Mohammed Al Jabori, 25M595051. Is he out there, Lisa?
I'm sorry, Judge. Who did you call?
It's Muhammad, Muhanad, Mohammed Al-Jabori, Jabori.
No, he's not.
Somebody wrote down defendant here, PO not here. The trooper Corby is not here, right?
He is not. Nope.
I'm going to go ahead and dismiss it for that reason. The trooper didn't show up. I gave them 15 minutes. It's 9:34. Case was scheduled for 9:15. Even if Mr. Jabori is not here, he'd be entitled to a dismissal. Case dismissed. Do you have one for me?
Judge, I have Tasia Miller. What's happened is prosecutor Nora Alawari is seeking an adjournment for 2 weeks because of the fact that she still needs time to talk with the complaining witness.
Okay.
Would you want me to place that on record since my client's on Zoom?
Yeah, let me call the case.
Judge.
People against Taja Sikora Dillard Kirk, 25W711367. Everybody's name.
Good morning, Judge. John Graziani appearing on behalf of defendant Dillard Kirk. At this time, we're seeking an adjournment. I spoke with.
Geez, they've had like about 6 weeks to do this.
Well, she's been overwhelmed, Judge. I was prepared to go forward, but she's a very diligent, hardworking prosecutor, and I have no problem.
Nice to see you advancing her cause.
Oh, no, Judge, I understand your position, but at the same time, she's very decent to me. And It's a legit.
November 4th at 8:30.
Okay, Judge, thank you so much.
Where's your client, by the way?
She's in Florida, Judge. There's
Ma'am, your name?
Tasia Dillard hyphen Kurt.
Good morning, ma'am. We're going to go ahead and adjourn your case until November 4th at 8:30. You can appear by Zoom. If it goes to trial, you're going to have to come here. I just want to caution you. You live in Florida, correct?
Yes.
So we listed you. Do you have your updated address, Lisa?
Yes, I do. We have a Tampa, Florida address.
Okay. Okay.
Judge, for the record, it appears that this matter will be resolved, but I don't want to get into any detail.
You don't have to. That's fine. November 4th, you show up at 8:30, ma'am, okay? If not resolved, then I have to set for trial, okay?
Thank you,
Yes.
Judge. Thank you.
Thank you, Mr. Graziani.
Thank you.
Have a good day, ma'am. Good luck.
Okay, you too. Appreciate it.
For Jason Stacy, I have his lawyer on text and he's having trouble getting into the Zoom. And he said if he could call in now and is there a number I should tell him?
Yeah, I'm sorry, who are you again?
Stephanie Stacy, Jason's mom.
Judge, I've got calling him right now because he never showed up. So hopefully. we can
Lisa, I
help him get
didn't
on
hear
Zoom.
you.
I have someone calling him right now because he never showed up.
I'm having a real issue. I'm not hearing you at all if you're talking to me, Lisa. I don't know what.
Me now?
Yeah, but Zoom ID down
Can you
there.
hear me?
I can't hear you hardly at all.
He's
Wait, just let me take care of this. If you will just give me 1 minute, okay? Something's going on with the sound over there, Lisa. Morning.
How you doing, Your Honor?
Good, thanks. You have any Zoom number? You just, if you want to give it to me, I will.
there you
Okay. Why don't you come on up here? This is the Zoom ID number, ma'am. Come on right up to my recorder here. Take care of that, will you?
Can you hear me now?
Say something again, Lisa.
I'm going to log off and log back in.
Okay, sounds good. Good morning.
Morning, Your Honor.
What case are you here on?
I'm here on Saadi Tahari for Attorney Samir Jadallah. Last name is Tahira. We're ready. I think it's a dismissal, Your Honor.
Okay, as soon as I get the file, I'll call the case, okay?
Thank you, Your Honor.
Well, this isn't he sent in
That might be mine, Your Honor.
Marion Rathor, 25M587-628.
Good morning, Your Honor. Greg Sheen on behalf of the respondent, Your Honor. I did speak with the prosecuting attorney and the trooper who was present. There's nothing that they can do on operating while texting. The trooper did observe my client holding the phone and he's gonna just be responsible as charged.
Can you pull that up? All right, you're authorized to send that plea on his behalf?
Yes, sir.
All right, to that charge, prohibiting holding or using a mobile device while operating a commercial vehicle. How do you plead?
Responsible.
All right, I'm going to accept the plea. That is 2/15. I can give him a week, okay?
Thank you, Your Honor.
October 28th. Have a good day.
You too. Thank you.
Hello?
Attorney Alamamne standing in for the attorney of record, Mr. Samuel Jadala, on behalf of Mr. Sam.
Okay, the name Jason. Hello. Give you the spelling here.
Stacy, he's in custody.
Oh, Stacy.
Yes, Stacy Simpson.
He's in custody. Yeah, I think his mother just asked for the Zoom ID. So, is he there yet, Lisa? Is he in the
Yes,
county?
he's here.
Okay, perfect.
Mr. Lakin, do you want the prosecutor or your client?
Yeah, the prosecutor is who I need.
Okay.
There's nothing else ready right now, right? All right, everybody stay seated, okay? I'll be back as soon as something's ready. Competency.
I did, and
You see it on your screen?
Stacy.
Mr. Ewald, do you need your client in a breakout room?
No, we're good.
Okay, all right.
hello?
Yeah. Did you speak to him?
I did, and we're ready to do a waiver and we're going to stipulate to the forensic report.
The file yet. As soon as I get it, I'll call it, okay?
Yeah, Judge, they may call me in for an exam and read for it. So if I have to sign back on, but I think I can get this done.
Do you have that file? Good. Got it. So let's see here. I should be able to.
Well, appreciate it.
He was on top.
All right. There was a forensic report.
There was for competency.
All right, so people against Jason Alexander David Stacy, 25R713-531. Your appearance?
Your Honor, for the record, Mark Lakin, P41147 on behalf of defendant Stacy.
All right, sir, your name? You have to get them to unmute you, okay? Mr. Muhammad, I'm going to want you here 1 second, okay? Mr. Stacy, your name?
Yeah, Jason Stacy.
All right, so your name?
Good morning, Your Honor. Mohammed on behalf of the people.
All right. So first of all, with regard to the issue of competency, does everybody stipulate I can use the report of the forensic examiner dated September 30, 2025 that was addressed to Judge Husson?
Yes.
Mr. Lakin?
Yes.
Have that marked Peoples 1. I'm going to go ahead and ask, nobody has anything else to say with regard to competency. Is that true?
Right.
Is that true?
Yes.
All right. The court having examined the report, parties having stipulated to the admission of Peoples 1, the court finds that the defendant is in fact competent to stand trial. He understands the nature and object of the proceedings against him and is capable of assisting in his defense in a rational manner. So I'm going to find defendant competent to stand trial. And now I'm going to go ahead and accept the waiver if that's what your client wants to do. That's what he wants to do, counsel?
Your Honor, I definitely have a different client, and I mean different in terms of whatever mental health issues he was having originally seem to have subsided with his medication. So he's definitely coherent and he's understanding, I believe, what I'm talking to him about. So I believe he would so with that, Your Honor, I would say he is freely and voluntarily waiving his examination today on my advice, but it's definitely his decision. And
All right,
our
I'll
plan.
cover that. I'll
Yeah.
cover that. Mr.
Okay.
Stacy, do you understand what your lawyer has said?
Yes.
You're charged with count 1 false report or threat of terrorism, a 20-year felony, using a computer to commit a crime, 20-year felony and malicious use of a telecommunications service. That's a misdemeanor. That's a 6-month. But as to counts 1 and 2, you have the right to a preliminary examination where the people would have to show that the crimes were committed and that you were the one who probably committed the crimes. If you waive your right to an exam, you are automatically bound over for further proceedings, will be to the Wayne County Circuit Court on all charges contained in the complaint and warrant. Do you understand that?
Yes.
Is that what you wish to do, is give up your right to an exam?
Yes.
You fully understand everything?
Well, I don't really know what the exam is.
Well, okay, let me cover it. The preliminary exam is a hearing where the people have to show that you were the one who probably committed the 2 crimes that are felonies here. False report or threat of terrorism and using a computer to commit a crime. If you waive your right to an exam, you're waiving the requirement that they come in here with testimony and show that the crime was committed and that you were the one who probably committed it. You're waiving that right to a hearing and you're going to be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes.
Do you wish to give up that right to a hearing?
Yes.
Anybody force you to do that?
No, this is my own free will.
You understand everything I've said totally and completely?
Yes.
All right, I'm going to accept the waiver. I find the waiver's been made voluntarily and understandingly. You're bound up for further proceedings to the circuit court. Judge Hessen set the bond of 500,000 cash. I'm going to go ahead and, barring any argument, continue that. I don't know anything about the case, but I trust that, I know she would be fair with them. So that's what I'll do. I'll continue the bond. You have no objection to the waiver or the continuation of the bond, correct, counsel? All right, good enough. So that's what I'm doing. October 28th, 9:00 in the morning there, sir. I wish you well. You'll be at the Criminal Justice Center in Wayne County, okay? Mr. Lakin, anything, you understand, sir?
Yes, we're all good.
Okay, good enough. Good luck, sir. Thank you. Kelly Ann Harp, 25M 603-674. Kelly Harp here. Ma'am, you have to start your video and state your name, please. Ms. Harp, you have to start your video and state your name, please. There you go.
Sorry.
Your name?
Kelly Harp.
I'm going to go ahead and dismiss your case. The trooper didn't show up. It was scheduled for 9:30. It's 9:59. We give everybody 15 minutes. Case dismissed. You are all set. Good luck to you. Thank you.
Thank you. Have a good day.
You too. Dominic Gaglio Construction, 25SO23337A and B. All right, sir. Good morning. Your name? You're the main honcho here, eh? All right. He's moving to dismiss. The prosecutor is saying you full compliance in the interest of justice. Proof of title and tarp repairs were provided. They're going to dismiss. Cases are dismissed. You are all set. Have a good day, sir. Good luck to you. Thank you. People against Alvarado, Marcelo Alvarado, 25T722-251. and 25T722228. Mr. Alvarado, you have to state your name, sir.
Marcelo Alvarado.
Okay, counsel, your appearance.
Good morning, Your Honor. Ed Wald on behalf of Mr. Alvarado.
So I'll adjourn the PCC 1 week after I take the waiver and the exam 1 more week. So we do October 28th and November 4th. Those dates good with you, counsel?
Yeah, 28th is still by Zoom?
Yeah.
Yes, that would be
Sir,
fine.
your lawyer, it looks like, would like an adjournment so he can further review discovery and consider whether or not you should proceed with the exam. You have the right to a probable cause conference within 14 days. He's asking for an adjournment. If I accept this agreement between the parties and adjourn this, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, Your Honor.
Do you wish to waive that right?
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
I'll accept the waiver. PCC will be October 28th. Can we do that at 8:30, Lisa, or you want a different time?
No, 8:30 is fine.
And then November 4th will be in person for the exam. And what is 10 o'clock good?
Sure.
At 10 o'clock. Okay, counsel?
Yes, Your Honor. Thank you.
Have a good day. Mr. Alvarado, you can appear by Zoom next week. The week after that, you have to appear in person here, okay?
Thank you, Your Honor. Have a great day.
Have a good day. Thank you.
Bye-bye.
All right. Okay. Gardner. Amaya Andrea Gardner Orange, 25M588735 A and B.
Good morning, Judge and staff. John Graziani, doing on behalf of Maya Gardner Orange. Judge, I requested an adjournment for 2 weeks. Her mother got in an accident. I did provide evidence, though, that this young lady, in fact, had a license. However, there's still a few.
I got it. No problem.
Just want to indicate that, Judge.
November 4th at 8:30.
Thank you,
Okay.
Judge.
I see what he wrote up.
Nash.
Eshkos for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Nash. Who's approaching? Mr. Nash, could you please state your name for the court?
Brandon Nash. Your Honor, this time you are requesting an adjournment. There are a couple of witnesses to prove this case against you that are not present today. So requesting just a 1 week adjournment.
Your Honor, we're moving to dismiss based on the prosecution's inability to proceed. It's Mr. Nash's third in-person trip here, and it's been very difficult for him to make that drive. He always has to rely on other people. And so we're asking for dismissal.
Well, 2 things. Well, the first thing is, so that we're clear, even if I were to dismiss today, the people would be reauthorized.
That's correct, Your Honor. I think the court is familiar with Mr. Nash. He is the person that is currently on parole in Kalamazoo County. And these cases happened when he came to Washington County. I say these cases, it's only one case today, but there's also a pending misdemeanor matter before, Your Honor. It's another retail fraud. So I do intend to reauthorize it, but we're dismissed.
So, Mr. Nash, you understand that if I dismiss it, you'd be subject to rearrest, incarceration, and it's be set again. You understand that?
Yes, sir.
And that's what you want to go through? I'll let you think about that a second, okay? Because I don't know that that's what you want to do, but you have a medical marijuana card?
No, sir.
Is the court reviewing community corrections report?
I am.
And for the record, we did discuss that at Mr. Nash's misdemeanor case, which was up past Wednesday. And if I recall correctly, I do believe the defendant indicated that he was using marijuana without a medical marijuana card and that his MDOC agents do not test him for marijuana, despite the fact that he is on parole. So I also have received that report that it does indicate continued presence of THC in the defendant's system.
And the court did admonish Mr. Nash that those levels needed to go down. And I looked at the community corrections report. And it looks like we're waiting on the tests that I think were like subsequent to that conversation.
Right. That was on the misdemeanor case.
I think we talked about it at the PCC last time.
But what the problem's going to be is that I'm actually going to be seeing showing up in his system, and irrespective of parole, that shouldn't be in his system on this case.
Right.
Or my misdemeanor case.
No, you're absolutely right, Your Honor. And I read the community corrections report that he told the officer, the community corrections agent, that he was quitting, and that the agent counseled him that he needed to quit. So I'm hopeful that those levels are going down.
Well, over the objection of defendant, I'm going to adjourn the preliminary examination in this case. Would the people be ready in a week? I'll let Mr. Nash and counsel pick the date. I can do next week, the 28th. Or
Preference of the people, just confirm Corporal Andrews, he's not available in November, so we just.
oh, he's not available. Okay. So I guess there aren't really choices.
Next week.
When do you come back and see me on your misdemeanor? I don't have it.
11:15, I think.
Okay.
11:12, I apologize. Or.
It would be the 12th. It's either the 5th. I think it's the 5th, right?
I think the 5 is the, but I'm pretty sure it's the 5th.
That sounds like something. Huh?
Can I say something, Your Honor?
Sure.
I have not been smoking. And when you told me to stop smoking, I stopped. And they making it seem like I'm still smoking weed. I'm not smoking no weed. I don't do drugs. When I, honestly, they making it.
Go ahead. I'll let you finish.
They just making it seem like I'm just still using. I'm not. I'm taking care of business like you asked me to do.
Hey, Mr. Nash?
Yes, sir.
I remember you telling me that. I'm also looking at these test results, right? If I thought you were just out there doing what you think that the assumption I'm making, what they're saying, then I'd solve that very quickly because you'd be incarcerated. I'd make sure you're not smoking. All right. It's not like I don't hear you and don't listen to you in terms of what you're saying. I recall that. All right. But from their perspective, this is to understand, it's appearing in your system, right? The only question I have is whether or not we can get results in terms of levels, which is really going to tell me. Okay. So trust me, and you've seen me before. When I make a decision, I'll make a decision. But I haven't made a decision. I'm trying to give you the benefit of the doubt. Follow me?
Yes, sir.
All right. Is when he set the night. We went all the way out to the 19th?
We did.
Okay. All right. Here's what I'll do. I'm going to, over the objection of defendant, and given the status of these reports, and he's got other matters pending before me in any event, I'm going to adjourn. I'll adjourn it out 1 week to October 28th, 2025 I'm at 9 that day.
No, you can't assume these hearings are like important hearings.
9.
Is that before Your Honor?
Yes.
Okay.
That will be before me. I'm going to set it on that date. I'm actually covering for Judge Washington, but this one will be before me certainly. And all right, and then we can, if they don't have their people, then I can make a determination at that point.
Thank you, Your Honor.
All right.
Got it. Thank you.
All right, bond will continue. All right.
Thank you.
Anybody seen Miss Virgil's?
I believe she's back in the cell talking to her client. I sent her a message on Teams, but I haven't heard back yet, Judge.
I can go check, Judge.
Pardon?
I can watch that.
Okay, thank you. Ms. Feltes, can you approach a separate matter? I was hoping that you would get help.
I made
Great, yes.
Yeah, she's
All right. Mr. Gio, since I'm watching you, you don't have to listen to Juan Green if you don't want to. You looked in distress. I see.
It's quite painful, yes.
Okay, go ahead, listen to him, but I'm just saying. Court does call the case of the people versus Michael Russell.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Michael Russell, who approaches.
Your name, sir?
Sorry, sir, I was in a slip and fall.
Okay.
I'm in excruciating pain. I think I need to
Can you tell
my
your
assistant.
name now?
Can I speak with my attorney? I have some misinformation.
You state your name for me.
Oh, sorry, sir.
Let you say what you're gonna say.
Michael Russell,
Thank you. All right, where are we on this?
assist other law enforcement, trespass offense. This was generated yesterday.
Yes, so from what I understand, there are aspects of the police report that Mr. Russell is asking to discuss with me further. I did show him the police report that was sent to me by the prosecutor's office last night.
This was created yesterday.
Would the court consider passing the case so that I can meet with him?
Sure. I will do that. I thought you might be ready, but okay, I got you.
I'm sorry, Your Honor.
No, it's okay. I've got other things I'm waiting on, so it's not a.
Thank you, Mr. Simpson.
I'll come meet with you.
It's kind of like, sorry, I had to. Anyway. So. Mr. Goldstein, we're waiting on your case. We're waiting on.
We plead no contest to those existing charges 1 and 2 on the issue of potential civil liability, and the people would further agree to a sentence of probation with no prison term. Any jail term would be up to Judge Hammoud, before which Mr. Russell would be sentenced.
And a correct statement.
That is our understanding of the plea.
All right, Mr.
you need to go somewhere, you go a different direction.
What is it address?
Is that not your mom's address?
I think that was that.
Oh, her employment potentially? I think that might be where she's employed. So talk to probation about that, but 5080 Helbig Road, you're not to be anywhere where your mom is, all right? If you're somewhere and she's there, you're the one that has to leave. Make sense? All right, good luck to you, sir. You can
I
go.
did have some misdemeanors. Would I be able to take care of those before I go to the street?
You have to take care of them before you go. Actually, there's a whole, you won't be able to go. And so we'll let the misdemeanor court know that this case is over, and hopefully they can get you over there on a jail run this week and you can get those taken care of. Okay? All right, you can go back with the bailiff. Yeah, go look and see which one.
Address may have been where the offense occurred. Yeah, I think because it was a rental house. It was like a rental house.
Oh.
Didn't know any address of anything.
Gotcha. Okay, thank you. Toy Hill, it's a sentencing, Ms. Holmes?
Toy Hill.
Can I pretty please get my water out of my desk? I'm sorry, I did not know.
Yes. I hate
This is no, is not, is it?
No. He's coming from Jasper. Mr. Wilkerson.
Oh. All right, ma'am, are you Toy Hill? And Ms. Hill, you were previously in court, entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State issue.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state, Your Honor.
My inclination, if I'm going to follow this agreement, is possibly based on some of the statements of family members as well as probation, is special needs safety. There's obviously some thank you so much. There's obviously some drug history and abuse of several different things in that list, as well as some mental health issues that need to be taken care of. And I think to get started on this probation, if I'm inclined to go along with it, that's what I would be inclined to do. Do you want to?
Yeah, I got to get a minute.
Yeah, visit with her about that, but that's based on the history, with same types of offenses. That's where I'm headed. So y'all can visit for a minute and then I'll take care of it, just so she knows what I'm talking about. Let's see. Mr. Cashin and Mr. Johns on Larry Williams.
Larry Williams.
Good morning, Junior.
Good morning. Morning, Mr. Cashin.
Good morning, Your Honor. How are you?
Great. How are you?
So far, so good. Better than a lot of people.
That's true.
There's been a few.
Good morning, sir. You're Larry Fitzgerald Williams. And in cause number 25, DCCR 0985, Mr. Williams charged with capital murder. And then the other case is a motion to revoke probation that Mr. Johns represents him on in cause number 24, DCCR 1790. It's not a motion to revoke probation. I'm sorry. The other case is an aggravated assault causing serious bodily injury. And so, Mr. Cashin, obviously your case is the top one on that. What is your announcement?
We are not ready to proceed yet. We need to get all the information from the DA's office. We have to review some of the evidence that they have provided. We want some phone records. I'm going to get with ADA about some of the phone records, the forensics on his cell phones, the forensics on the phone of the decedent, and a couple other things that we have to do.
And do you have everything in your possession to turn over at this time that you know of, Mr. Smith?
As far as I know, Judge, we do.
Okay, if y'all will just get together and visit about that, if there's something that Mr. Cashin needs that you don't have, if you'll get with law enforcement, let's get everything. And then what I'm inclined to do, just based on upcoming holidays and things like that and resets, I'm inclined to give a longer reset, but I don't want y'all to wait till the last minute. If I do that, go ahead and get everything, visit. I'm going to do a reset to maybe that first week in January. That should give y'all plenty of time, hopefully on a case of this nature, to get more up to speed. And then I'd like an announcement if we can on that date.
What I was expecting.
Okay, sounds good. Then we'll see you back then. Thank you, sir. You're free to go. You can go back with the bailiff, sir.
Thank you.
Yes, sir. Thank you. Ms. Holmes, are y'all ready? Yes. Let's go back on Toy Hill. All right, is everyone ready to proceed with sentencing?
Yes, Judge.
And Ms. Hill, in cause number 25, DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault family violence by impeding breath or circulation. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete this special needs safety program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on this probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff. And then you've got Jasmine Hancock. It's a bond hearing.
Yes,
And is that on all of the cases or
it's just on two. He had two cases that he had $100,000 bond on.
Oh, I see. Potentially because he got a new offense while he was on bond.
No, I think it was a forfeiture. He missed a court date because he was in the hospital.
Okay.
That's my understanding.
There is also that new offense.
Oh, okay.
Which is, we'll talk about it, but that date of that offense is after. All right, so you're Jasmine Hancock? And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April. Well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at 100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well. Go ahead.
He's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
Really? You're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janesha Butler.
Janesha Butler?
Jamesh.
JAMAYSHA.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. I don't know if you need to do, if I need something in writing on that third case that I just raised.
Defendant's mom in car accident cannot appear. We'll adjourn it to November 4th at 8:30. Thank you. People against, Andrew Lee Johnson Jr., 25M591389A and B.
Good morning, Your Honor. Trustee spoke on behalf of Mr. Johnson, but this matter is going to proceed by informal hearing between the trooper and Mr. Johnson. So,
You're a lawyer.
yes.
So well, I'm not understanding. You entered an appearance, so you can't appear in an informal.
Right. So,
Mr. Johnson, your name? Trooper, your name?
Your Honor, Officer City, Michigan State Police.
Wait, counsel. Any objection to your lawyer, Ms. Baraka? Am I pronouncing that correctly? Sproka, withdrawing What happened? They wouldn't give you anything? Is that what happened or?
We reached a resolution, Your Honor. I'm willing to dismiss the improper lane use, Swerven.
Okay, so I'm gonna allow you, Attorney Sproka allowed to withdraw. Let me just make a note of that first. So you're all set, counsel. So now it says we'll proceed with an informal hearing. And I am gonna let the lawyer withdraw. No objection from the defendant. All right, so just give me 1 second to make some notes here, if you would, please. All right. So what are you going to do now?
I'm willing to dismiss the improper lane use, Swerven. And then, keep the, ponies.
Boy, that texting law isn't working. I see people all over the place with texting and.
Yes, Your Honor, they want us to take, enforcement on it now, so we have to write something back.
All right, is that what you want to do, Mr. Johnson, is plead to operating while texting with the understanding the improper lane use will be dismissed?
Yeah.
Can I see that, please? All right. To the charge operating while texting, responsible or not responsible?
Responsibly.
Okay, I'm going to accept your plea. Yeah, it's 2:15. And then I'm going to dismiss on motion of the officer, the improper lane use. 2:15, you can go down the hall and take care of that and you're all set. Best of luck to you, sir.
Thank you, Your Honor.
Thanks a lot. Thank you.
You know,
$700, true? Corporation. People against Gilbert and Lewis Trucks. 5S118251. Your name?
Frederick Gilbert.
What is your position with the company? Are you the president? So, I mean, is this a corporation?
Yes, I think,
And you're the president?
yes.
All right, so you're going to plead to overweight and there's agreed upon fines and costs of $700, true?
Yes.
To that charge on behalf of the company, responsible or not responsible? Plea is accepted, $700. Can you pay that today or do you need some time? I don't mind. Which? Okay, you're gonna pay now?
Yes.
All right, have a good day. Good luck. You can write down the cashier. Thank you.
thanks, God.
Nicholas Gray Witz, 25 D237026. Good morning again, Mr.
Judge and staff, John Gratiani, appearing on behalf of Nicholas Woods for the purpose of the amendment before you.
Sir, your name?
Nicholas Woods.
And then this is going to be a plea to failure to display an ORV license decal, right?
That's correct, Judge.
Is that what you want to plead to? That's a civil infraction, sir.
Yes.
To that charge, failure to display an ORV license decal, responsible or slash not responsible? I'll accept the plea. 175, original charge is dismissed. You can go right down the hall and take care of that. And you have the money, right? Okay, you're all set. Good luck to you. Is that it?
Judge, I'll have one more that are going over it right now, so.
Take your time.
Okay, Judge. And there's also a lady out there her son's attorney hasn't shown up. She's been with him since 80.
Where is it?
Let me Williams again, the attorney.
Is that a probable cause? Exam?
It wasn't set for 8:30 though. It's set for 10:15.
Apologize, that's what she indicated to me.
Did Philip Kowski check in? It's an arraignment pretrial.
Did not check in with me, no.
Okay, it's an attorney general case and I have them on Zoom.
What time was that scheduled? 10:30?
10:30.
It was in the second.
Lisa, can you call Mr. Williams, find out where he is? If not, I'll call him. If
Yeah, I'll
you
call him.
Okay.
What? Yeah, it wasn't in the stack this morning. I didn't check it out this morning, so it wasn't.
Thank you. I think that.
All right. Come on. What are we doing here?
We're waiting on.
They plead no contest.
Mr. Russell, you're going to waive your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Understood, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts. Ms. Reed.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
November 3rd at 1:30 with Judge Middleton.
November 3rd, 2025, 1:30 before Judge Hammoud.
Your Honor, may I address bond?
You may.
Your Honor, we're asking for a personal bond in this case. This is the only thing holding him at this time. My client stays in Washtenaw County. He has an address with a relative he can stay with. He has a good relationship with his family, has been in communication with his mother, who is supportive of him. He also helps take care of his father, who is at a senior center in Milan. Close with his siblings as well. He's employed in construction and cleaning, has his own business. He really wants to get back to that. Of utmost concern to my client at this time are his health issues that he is suffering from. He has high blood pressure, which can be very dangerous, and is had a recent fall at the jail that severely injured his back and neck. He believes he needs to go to the hospital. He would like to seek medical treatment for that urgently outside of custody. So to be with his family, to continue work, and to seek that medical treatment, we're asking you to consider a personal bond.
Response.
Your Honor, the people would object. Facts of this case, Mr. Russell was found trespassing at a lot in Ypsilanti. Officers observed him as someone who matched the description, been there the night before, and was believed to be stealing items. When the officer said to stop, he ran. Additional officers arrived on the scene and chased him. He hopped a fence. 2 officers hopped that same 10-foot fence, dropped down. The officers were injured. One in particular suffered scratches on his arm as a result of this. Mr. Russell still refused to stop. Eventually, he had to be tased in order to stop him. And then he was taken into custody from there without further incident. This is not the first time that he has gone with the police. He has a history of resisting, fleeing, and eluding. He's been sent to prison for this on multiple occasions. While we have reached a resolution in this matter that does not involve prison, the people believe that he should be released after this case is ultimately resolved with the proper safeguards and guardrails in place so that he can maintain whatever his issues are and get those under control before his release.
Anything from?
Yes, Your Honor. Although he is interested in that plea deal at this time, the allegations remain allegations. This is the only thing holding him. I believe Mr. Russell would attend future court dates and fully intends on complying with any probation he's sentenced to. I would ask the court to consider release on a tether, if not just a personal bond.
Well, given the fact that there were, they said, alleged that officers were injured, but also he does have a history of flight from authorities, the court would consider him a flight risk at this time. I'm going to deny your request. Certainly, Judge can take a look at it and make a determination as to how she wishes, if the defendant's released, how he would be released in the circumstance. So, motion's denied, bond will continue. Thank you.
Thank you, Your Honor. Have a great day.
Thank you. You too, sir. Ready? To best hand. Of course, everything I had left is mistake. I didn't say that badly. I just said that because we have to wait and see what happens.
I got my papers on.
Huh? Were your Pumas? I got my Under Armour's back there. So I'm ready to run. Court does call the case of the people versus Kamani Barfield.
Good morning, Your Honor. Mary Tennis, the prosecutor, attorney on behalf of the people. Just an attorney.
Sorry, Assistant Public Defender Chelsea Vergils on behalf of the defendant. We are asking to adjourn.
Sorry, I thought that she was here. I'm so sorry.
Is she? I don't know.
She was here. Oh, I'm sorry. I apologize, Your Honor. Someone can track her down. She was speaking to Mr. Brown.
Oh, okay. All right, I'll pass it. She's out though, right? I'll pass it. Mr. Brown left?
You already came on.
Yeah, that's right. Come on, Bishop, get on it.
Oh, thank you. Sorry about that. Okay.
She's said, and it's like, sometimes they are, sometimes they'll stop. That's just what I call her in one country. I don't think she. There's a lot of like.
Or you think Mr. Nichols is going to give you some great deal? It's not happening. And what about the new case?
That's gonna be not true. Commissioners didn't watch after that.
Okay, give me just a second. All right, are you Victavia Sanders? All right, give me just a second.
So complete truth to it. We agreed with the community service and complete truth to not be a community
So there's still, our tablets are still messed up. And we only have one? We have two. Oh. Sorry, it's coming. All right, will she waive the formal reading of the motion?
So
Ms. Sanders, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And so, Ms. Sanders, in cause number 22-39884, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property with previous convictions. And that was a 2-year state jail term that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions July 31st of 2025. And is that true or not true?
No,
not true.
yeah, not true.
Count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
Yes, ma'am.
It's true. Yes, that's true.
Not true.
Count 3 alleges that you're behind in your court assessed fees as of August 19th, 2025 in the amount of $919. And is that true or not true?
That's true.
Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And we'll need, I guess, some time for witness.
Probably about an hour, Judge.
Okay.
We can do it at 11 o'clock on the news.
Okay, so we'll reset it to where we have about an hour or so for any prove up of count 1.
And she's requesting a bond, although it is a straight probation case.
Has there anything been filed?
Should have been last night. But he filed yet.
Okay. Yeah, we're not having any trouble with those. He dropped it down. Sorry. Let me make this notation first.
Figured out if she doesn't even
Mr. Smith, what is your position with regard to a bond?
State's opposed to bond, Judge. We're seeking state jail time and the new offense as well as.
Speak up, please.
The state is seeking state jail time in the new offense as well as the MTRP.
Okay, let me look at something and then I'll. I should be able to go back and see. Yep. So I'm going to take a look at the original pre-sentence report. That'll just help give me some information about history and what got us here in the first place. No, that's denied at this point. This is her one, two. She's on probation for her third felony and now allegedly committed her fourth. So that's denied. We'll get it set for a sentencing hearing and take care of it on that date. You can go back with the bailiff. Unagreed, yes, ma'am.
Can you send that rejection back to Mr.
It's working? Good.
On Calvin Randall, and need a little more time to talk to him again.
Okay, give me just a second. I will call it. And is that the only one you have?
Yes, sir. It's a trial status.
Okay. Is that Mr. Randall? All right, Calvin Randall, y'all can come up, please. Good morning, sir. You're Calvin Randall. And Mr. Randall has 3 cases and 24 DCCR 1278, aggravated assault with a deadly weapon, 24 DCCR 1529, unlawful carrying a weapon on alcohol premises, and 24 DCCR 1530, and evading arrest or detention with the use of a vehicle. Mr. Eckhart, what is the announcement?
Judge, Mr. Randall was previously revoked on a different offense that's not listed here. Philip has made a very fair offer. And we were going to fill out a rejection this morning, but we need a little bit more time if the court will allow us. I think we're still kind of weighing our options.
Okay. And so what I'll do, any issues, Mr. Smith? So Mr. Randall, I'm going to reset your case one more time. Mr. Eckhart will be out to visit with you about all your options, and we'll get an announcement at that next court date. All right, you can go back with the bailiff. What?
I know. That's why I was kind of the idea not to do that.
Let's see, Nathan Lamel, Mr. Kimler, this is sentencing.
One right here.
Good morning, you're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count 1 that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
And go
just,
ahead.
so you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review, have corrected them in 7 and 8, I believe.
Okay, so
That's
there
why
was a
it's
first amended.
yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those please don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count 1 alleges that you were arrested. Okay, so did you want to?
Abandon 1 and 2, Judge, and show that they're correctly reflected in the First Amendment 7 and 8 committed.
All right,
That's
so.
what you didn't like that arrested for last time?
Well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay. So 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true?
Yes, sir.
Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025, you tested positive for alcohol. And is that true or not true?
Yes, sir.
Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true?
No, sir.
And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true?
No, sir.
Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true?
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay.
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I could do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but so go in and do the substance abuse track followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. If that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, you know?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking, moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
Ronia.
I'll represent the court.
Ronia Parkerson. I'm asking him. I'm asking
I
him.
understand that she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
He is not.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you want to have her brought in?
Oh, we can just have her brought.
Would you please call the name Aronia Parkerson?
So, drug substance abuse.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your may the record reflect that the witnesses identified the defendant in this hearing.
The record will so reflect.
Judge, on Saturday, April 26th of this year at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made?
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed. And the officers explained to me that if I called them back, that the trespass warrant would be voided. I was okay with that because I knew I was gonna call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also in my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point, I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you
Like,
still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay, and is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lavelle?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am, I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more productive?
Yes, ma'am.
And he can help you raise those babies?
Yes, ma'am.
Thank you. Pass it on.
I have no questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
No.
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
A little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry?
I'm sorry.
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations, okay? All right, good luck to you, sir. And then I'll sign a dismissal in that other case. Ms. Malfino, I guess, you'll send that through? I'll sign that dismissal. Okay, thank you. Okay. Let's see, is Mr. Cashin here? Mr. Johns, is Mr. Cashin, have you heard from him yet this morning? Have you heard from Mr. Cashin?
I talked to him yesterday, and he said he's gonna be here.
Okay.
I'm certain.
Interstate 10 right now is up and down.
That's all right. I'll just hold the case until he gets here. Thank you. Mr. Matuska, you've got Traylon Hill. Good morning. How are you?
Good. Good morning, Your Honor.
Good morning.
Yes. Thank you. You're going to fill out an affidavit of your income and expenses to me to determine whether or not you qualify to have an attorney appointed. And I'll come back to you on the second call to determine that issue. Yes, Your Honor. Docket number 15072, State versus Brendan Davon Durr. Brendan Davon Durr, B-U-R-R, for status, actually attorney status and status of the case. It shows on the docket that the defendant called on October the 7th to let us know that he got his dates fixed up. Judge Wolf, in the exercise of bad judgment, apparently authorized moving the court date to October the 21st, 2025, and he is not here.
Yes.
All right, what is his bond?
A $3,500 bond with NBA bond.
Be a conditional forfeiture of his bond in the amount of $3,500. The citation of bond and accompanying duty to settle 6 months down the road. The final forfeiture. Charges for the defendant's arrest, new bond will be $10,000.
Yes.
And if he calls you back this time to say that he got the wrong dates, you might want to explain to him that's not going to be an acceptable excuse the second day out. So. Docket number 15137, State versus Justin Micahs Eastel. Except you're here to be arraigned on an indictment charging you with possession of methamphetamine, unlawful drug paraphernalia, failure to appear, and driving while in possession of methamphetamine. You have the right to a lawyer. If you wish to have a lawyer,
Yes.
Are you planning on hiring a lawyer?
Yes, sir.
You're going to hire your own lawyer. Do you want me to read this indictment to you here in open court, or do you want to read it yourself?
I read it myself.
So he waived the formal reading of the indictment, enter a plea of not guilty. How long do you expect it to take you to hire a lawyer?
Maybe months. This month.
All right. What's the step? What do you wish to do, Joe?
Judge, we can set it for attorney status on November the 12th, and go ahead and set it for trial on April the 23rd of 2026, with the plea date of April the 14th, 2026.
All right. Attorney status of November 12th. I've written these dates here, and what that means is you need to be back with your lawyer on November the 12th, 2025. Those other dates are the trial dates, and I put them on your docket as well. So, thank you. Number 15138, State of Tennessee versus Chevy O. Forrester. Mr. Forrester, is that you here for jail?
Yes, sir.
You are here to be arraigned on the charge of theft of property, burglary of a building other than a habitat of non-public building, and introduction of contraband into a penal facility. You have the right to an attorney. Do you wish to have a lawyer?
Appointed, sir.
Public defender.
Waiting for reading the indictment, enter a plea of not guilty, Your Honor.
Public defender has been appointed. Plea of not guilty is entered. He's been given a copy of your charges. He'll be up to talk with you and get you ready for your next court appearance. What is that?
Put that on November the 12th, Judge, and we'll set the trial on that lost dates.
All right, November the 12th will be your next court date, and we'll see if the state and the defense can agree on anything. If not, we'll set it for trial. Thank you.
Thank you, sir.
Docket number 15139, State versus Darrell L. French. French, you are here to be arraigned on an indictment charging you with possession of methamphetamine with intent to sell or deliver. simple possession of a Schedule 6 drug, possession of drug paraphernalia, unlawful removal or alteration of a registration tag, financial responsibility law, and non-light law of the motor vehicle laws. You have the right to an attorney. You wish to have a lawyer represent you. Are you planning on hiring a lawyer? I'm sorry?
I'd like to hire a lawyer.
You want to hire a lawyer, all right? Then, do you want me to read this indictment to you in open court, or do you want to read it yourself?
I agree.
Shall we waive the formal reading of the indictment? Plea of not guilty will be entered. How long will it take you to hire a lawyer?
60, 90 days.
Well, I'm going to give you another status date of November the 12th of 2025 to see if you hire a lawyer by that time. What about the rest of the day?
Your Honor, it'd be April the 14th for final plea day, April the 24th trial.
And April what? The trial?
24th.
24th. So you're going to have a last opportunity to settle your case by an agreement on April the 14th of 2026, and then your trial date is going to be April the 24th of 2026. So you need to be back here. I've written all those dates in there, but your next court date here is going to be November the 12th.
Okay.
Docket number 15140, State versus Anthony Cooper Guthrie. Mr. Guthrie, you're here to be arraigned on the charge of possession of methamphetamine or casual exchange, misdemeanor possession or casual exchange, and also another count of simple possession of casual exchange. You have the right to a lawyer. Do you want a lawyer to represent you?
Yes, sir.
Public defender?
Yes, sir.
White form read the indictment, enter plea not guilty, Your Honor.
Plea not guilty is entered.
Put that on November 12th, Your Honor.
November 12th. Your lawyer will be up to talk with you as soon as he's able.
Yes, sir. Thank you.
Thank you. That case is 14675B, State versus Tara Faye Hall. Show that you have a motion.
Yes, Judge. She's going to be brought down. I think we're going to reach an agreement, but there's some details to work out. If we could just second call her.
All right, put in a second call for a bring down. Bring over, I guess.
Well, I got to make sure she agrees too.
Not much of a decline. 15141, State versus Christopher Hayes Haskins. Mr. Haskins, you're here to be arraigned on indictment charging you with possession of methamphetamine with intent to sell and distribute, simple possession of Schedule 6 drugs, simple possession of Schedule 3 drugs, possession of drugs paraphernalia, driving without a license, and failure to appear. You have a right to a lawyer. Do you wish to have a lawyer represent you?
Yes.
Are you on medication or under any influence of any narcotics at the moment?
No.
You appear to be, that's why I'm asking you.
No.
But why are you acting the way you're acting?
Been up all night with my cousin. She's sick.
You've been up all night with what?
My cousin, she's sick.
All right, so are you planning on hiring a lawyer?
Yes, sir.
You are. Do you want me to read this indictment to you, or do you wish to read it yourself?
I'll read it myself.
So we waive the formal reading of the indictment. Plea of not guilty will be entered. Gentlemen, what do you want to do about the trial dates?
Trial date will be plea day, April the 14th, trial, April 15th.
What? And how long do you think? Do we have a December date or January date?
December the 9th, December the 12th, December the 16th,
And then
January.
December the 9th. On December the 9th, you need to be back here with a lawyer so that we can make sure you've got a lawyer representing you before your trial date in April. So make sure you get a good night's sleep when you come back. All right, at the jail, State versus Charles R. Herman. Herman, you're here to be arraigned on an indictment charging you with possession of methamphetamine with intent to distribute, DUI, first offense, implied consent, driving on a revoked license, and unlawful drug paraphernalia. Have the right to an attorney. Do you wish to have a lawyer represent you? Public defender will be appointed.
White former in the indictment, enter plea of not guilty.
Plead not guilty is entered. Dates, Joe?
Plea date, April the 14th, trial day, April the 16th.
All right. Public defender will be up and talk to you. We'll move to page 7, document number 15143, state versus Amanda Christine Hollis. Ms. Hollis, you're here to be arraigned on an indictment charging you with making false report to a police officer, tampering with evidence, as well as possession of unlawful drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer represent you?
I've hired Jake Walker as my attorney.
Who, which locker?
Jake.
Jake Locker, all right. And Mr. Locker is not here today, but do you want to stand in for him for arraignment? Yes, sir. But you've actually hired him to represent you, is that correct?
Oh, yes, sir. I thought I was pleading out today.
He has reached out to our office, Judge, saying he represented her. I don't know if he's filed anything.
If he's supposed to be here, as far as you know,
Yes,
this is
sir.
just for an arraignment, so we'll show that he is the lawyer. We'll show that you want a formal reading of that indictment.
No, Your Honor.
On behalf of Mr. Locker, Mr. Cooper is waiving the formal reading of the indictment. A plea of not guilty will be entered. And what dates do you want to?
November, put it on November the 12th.
November the 12th will be for status. If Mr. Locker can get something worked out for you as quickly as possible, then he can let us know. Right now, he's not here, so.
Can I ask for bond reduction at this time?
Pardon?
Your Honor, may I ask for a bond reduction at this time?
You can ask for a bond reduction because you have a lawyer. That lawyer is going to have to be present for a bond hearing. So you need to contact Mr. Locker and find out why he's not here today and tell him that you want to try to get a bond reduction. Okay?
Yes, sir.
All right, thank you. Next case is 15144, State versus Joshua Chad Hopkins. All right. So that Mr. Flanagan is the attorney for the defendant and waived the formal reading of the indictment. Plea of not guilty is entered. Gentlemen.
Your Honor, April the 14th for plea, April the 17th.
Right. Jail document number 15092A, State versus Justin E. Jones. Mr. Atchison, or as you're now known, DUI Mark.
Good morning, Judge. Your Honor, Mr. Jones is on the docket. I had filed a motion for a mental health assessment. Whenever it's taken up, I can speak to General Horn about the motion.
We'll put it on the second call. You can talk about it and we'll hear it. Docket number 15145, State versus Jeremy H. Lavender. Lavender, you're here to be arraigned on the possession of an indictment charging you with the simple possession of methamphetamine. You have a right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Planning on hiring a lawyer?
I would like to hire an attorney. I'm currently in a drug rehab and my release date from there is 3rd of November. And so if I could have a week or two after that, then I would certainly be able to.
What dates are you wanting to assign this trial?
Judge, we just put it on November the 12th for status. That'll give you a chance.
Right. November the 12th for your status, and that will be giving you an opportunity to hire a lawyer. So be back here at 9 o'clock on November the 12th. Let us know who you hire. Okay?
Yes, sir. Thank you.
Number 15146, State versus Cammie Gale Lewis.
Sir, have a seat, please.
Cammie Gale Lewis for arraignment. We'll put it on second call. Let's see if we can locate person. Docket number 15147, State versus Mason Parker Lewis. Mason Parker Lewis.
He's with Mr.
Carrot.
Barry.
Docket number 15120, State versus Shawanda M. Lombardo.
That is my case. She also has a new arraignment. I've been in touch with her. I'm not sure where she's at this morning. I know she lives a ways away and doesn't have a license, so she may be running late. I'll try and get in touch with
I'll
her.
put it on the second call to give you a chance to find out. Docket number 13758A, State versus Art Portillo Lopez Jr.
Judge, that's also mine. I don't know if he's on Zoom.
He's in jail, so he would be.
Number 1, on August 27th of 2025, the defendant was convicted of domestic violence, a felony 4, and an attempted abduction, a felony 4, through Claremont County Common Pleas Court.
Has he been sentenced on those?
Yes, Your Honor.
Sentenced to prison, I take it?
Yes, Your Honor.
All right, Mr. Davis, first off, do you understand the allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you. Do you have the funds to hire an attorney?
No, I don't have the funds, sir. I would like to go ahead and get it done today, though, if possible.
Okay. Mr. Lawson is going to hand you a form. It's a waiver of counsel that you need to sign for me, please. All right, that's your signature?
Yes, sir.
Do you understand what this document says?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
All right, the court's going to find that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I'll accept that. With regard to the allegations, I take it you'll admit to those allegations?
I admit, yes, sir.
Okay. What sentence did you receive from Claremont County?
For 2 F4s, I received 15 months each, ran consecutive 30 months.
All right.
The judge said that since I was on probation here, that he would run it consecutive that way, so.
Okay. Anything from the state?
No, Your Honor.
All right, Mr. Davis, based upon this violation, the court is now going to terminate your community control. Obviously, you can't remain on community control while you're serving your prison sentence. So based upon this, the court's going to order you to serve 12 months in prison on count 1 and 90 days in the Warren County Jail on count 2. Those to be run concurrent with each other and concurrent with your current sentence. Do we have a jail time credit for him on this?
69 days.
69 days jail time credit. All right. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. You are also, on this case, subject to a discretionary period of post-release control. I think what you're currently on is discretionary too.
Yeah.
What that means is that the Adult Parole Authority may supervise you for up to 2 years following your release. If you violate that supervision, the Adult Parole Authority, can return you to prison for up to 1/2 of this original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Okay? Good luck to you, sir.
Thank you.
Mr. Oswald?
Case number 25CR42762, the State of Ohio versus Deshae Bradford. Ms. Bradford is before the court with her attorney, Mr. Oswald. Ms. Tranter, on behalf of the State of Ohio, we're here for sentencing. Ms. Tranter, anything on behalf of the state?
Nothing further, Your Honor.
Anything from probation?
Nothing further, Your Honor.
Mr. Oswald.
Your Honor, Ms. Bradford's 23 years old. She's single with one child that's 3 years old. She's living alone and doesn't receive any child support. She is a high school graduate. She does have employment available to her by being a secret shopper. With regard to this case occurred on March of 2024, so it's been nearly a year and a half. This case where her, at the time, boyfriend manipulated her into illegally conveying Suboxone into the prisons. Since then, with this court, she was on EMU. She did not violate. She's complied with all pretrial services, and she's on supervision to Toledo. She hasn't violated any of that probation. So I think she can show the court she's amenable to community control, and for those reasons, we're asking to impose that.
All right, Ms. Bradford, is there anything you'd like to say?
No, not really. I don't really have much of a support system, especially when it comes to my son. I really only have my mom, and my mom works now, so yeah, that's that. And my son is also autistic, so it takes like that right there is a whirlwind, a little including single parenting. So if anything were to happen besides community control, I just don't know how I would navigate that situation. Prior to this, when I went to go check in with my probation officer, the indictment was put out and I went to jail. I was in jail for 3 days in Lucas County, and then Warren County came and got me, and I was in jail 4 days down here. So, and that was a lot on anybody who had to take on the load of taking care of my son, which was my mom. But she works now, so I don't even know like how I would navigate that if I were to be taken away. I'm being told that you said local or this one?
The PO was recommended.
Yeah, the PO recommended some jail time, and I just don't understand that. Anything, like he said, I haven't violated my probation that I'm on in my city. I haven't violated the EMU that I was on when I got released from jail, the ankle monitor. Like, I'm not understanding the jail time part because
Well, that hasn't been ordered yet.
I know, I'm just saying like.
Well, the jail time part, I mean, part of the sentence is to punish you. You broke the law,
Yeah.
right? That's what that's for. But it hasn't been ordered yet.
I know, I'm just saying it
Well,
wouldn't be.
here's what I would say to you, Ms. Bradford. I mean, you broke the law. This is a felony of the third degree. We have a problem in our prisons of, for whatever reason, young women get conned into taking drugs into the prison, and it's a problem. It really is.
See.
You understand that, don't you?
Yes.
Here's the other part of this too, and I understand. I have a child with Down syndrome, so I understand the need to be there. If you want to be there, just don't break the law, right? It's really pretty simple. Follow the law, and you don't end up having to go to jail and risk losing your child to the children's services, right? Anything else you want to tell me?
No, and like he said, it's going on 2 years since it happened. I would think if anything was to come of it, it would have been happened. Like this just kind of popped up out of nowhere for me, honestly.
Yeah, I don't have any control over that.
Yeah.
All right, anything else?
No.
All right, the court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court does find that you are amenable to community control. And Ms. Bradford, I have taken into consideration the delay in your compliance. I guess you were placed on community control in Lucas County after this event occurred, before you were indicted. Is that right? I got the timing right? This happened, and then you had the assault on a police officer in Lucas County, and then you got indicted on this, right?
Mm-hmm.
Is that the order of events?
Yeah.
You don't seem too sure.
Yeah, because it's a while for both cases.
Well, this happened in 2024. The
And
assault
that
on
one
the
did
police
too.
happened in 2024 as well. Did they happen around the same time? Because it looks like you were placed on community control in Lucas County in March of 2025, so that was this year.
Yeah, I just got on probation.
And then you were indicted on this case. Okay, I understand. All right. So you're going to be subject to the supervision of the Warren County Probation Department. Now, your day-to-day supervision is going to be transferred to Lucas County since you're already on supervision there. But you must understand that if you violate the rules and conditions that I set forth, you still have to come back and answer to me. Do you understand that part?
Yes.
All right. So I want you to complete the Thinking for a Change course. I want you to get full-time employment. I want you to get some sort of verifiable employment. Where are you working now?
I work with a temp agency called Labor Max.
All right, I want you to work on that employment piece. And you have your high school degree?
Yes.
Okay. All right, I am going to order you, well, what's the jail time credit?
7 days, Your Honor.
Does that sound right? 7 days jail time credit?
Yeah.
All right. I am going to order you to do 180 days in the Warren County Jail, but I am going to suspend all of those days on the condition that you comply, okay? So you're not allowed to use drugs, you're not allowed to drink alcohol, and you're not allowed to smoke marijuana. We understand each other?
Yes.
Okay. So on the condition that you comply, I will not require you to serve those days in the Warren County Jail, okay?
Yes.
Now, you're also subject to discretion. Oh, one other thing, you are trespassed. Do you know what that word means?
Trespassing, entering someplace.
Yes.
Yeah.
You are trespassed from all Department of Corrections facilities. So you're not allowed to go to any prison or any other facility that's operated by the Department of Corrections. Do you understand that, what I mean by that?
Yes.
So some random guy calls you, tells you to bring drugs into the prison. Not only is that illegal, but you're be violating my order too, right?
Yes.
Okay. All right, you're also subject, subject to a discretionary period of post-release control, which means that if you are sent to prison on these charges upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. And I do find that you're indigent for the purpose of any fines, costs, or other financial sanctions. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you can't afford an attorney, I will appoint one for you at no cost. Do you have any questions for me?
No.
I really want you to improve your attitude about this too, okay? I'm not your enemy here, okay? I'm trying to be fair with you, but you kind of got a little bit of an attitude with me, and I understand you don't want to go to jail. I get that. Don't break the law. Follow the rules of probation. Officer Fisher, someone's going to want to talk to you for a little bit over in probation before you head back to Toledo, okay?
Okay.
Do you have any questions for me?
No.
Are there any questions about what I've ordered?
No.
Okay.
Your Honor, can we also have no contact with the co-defendant, please?
What's his name?
Cavandre Walton.
Do you know him?
Yeah.
Is he still in prison?
Yes.
Devondre?
Cavandre with a K. Kevondre.
Walton?
Walton.
Yeah. You guys still friends?
Not really.
Good. No contact with him, okay?
Okay.
All right, any other questions?
No.
You gonna improve your attitude?
Yes.
All right, very good. Go see Officer Fisher.
Ms. Gaba?
She was out in the lobby.
Thanks, Karen. This is case number 24CR41676, the State of Ohio versus Brittany Gaba. Ms. Gaba, the court has received a report that alleges that you have violated the terms of your community control. Officer, can I have a statement of that allegation, please?
Your Honor, it's alleged that Ms. Gaba violated community control rule number 1 on September 5th of 2025. The defendant was convicted in Montgomery County Common Pleas Court on 1 count of felony 5 theft.
Ms. Gaba, do you understand the allegation?
Yes, Your Honor.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No.
Do you want me to appoint you one?
No, it's okay.
Why is it okay?
I mean, I'll just go in front of you today.
Ms. Gaba, when I sentenced you back in November of 2024, did you complete recovery court, or are you still in recovery court?
I'm recovery court. I didn't get to get in recovery court, but I'm in programming. I'm in Sojourner. I've been in it for a while now.
What's your medical condition right now?
I'm pregnant. I'm due in 3 weeks.
She tested recently?
I just did today.
Was she negative?
Your Honor, I apologize. I do not have that in
It's
front of
okay.
me right now, but I can find out.
Are you on probation, or have you been sentenced in Montgomery County?
Yeah, I'm on probation there.
Ms. Gaba, I told you when I sentenced you that you only had one shot to get this right. Do you remember that?
Mm-hmm. Yes, Your Honor.
I said, in bold letters under sentencing, I said, only chance. Are you still taking methadone?
Yeah.
What does that do while you're pregnant?
I can't get off of it because I'm pregnant. I couldn't get
Is
off.
your baby going to be addicted to methadone when you deliver?
Well, I mean, I go to the baby doctor and stuff, so I couldn't get off of it even if I wanted to. I have to be on it.
This is your second violation this year alone. What was your first? You had a misdemeanor conviction back in April. What was that for?
It was from back in April. It was from a theft.
So you stole in April, and now you have a felony theft conviction on top of that, all while you're on supervision with me.
This was from a year ago.
This one's from a year ago?
Mm-hmm.
Officer Cal, can you confirm that? You don't have to do it right now. I think you need to talk to an attorney. Because when I tell somebody they only have one shot at doing this, I mean that. And now you have are you on supervision in Montgomery County?
Yeah.
Give her an affidavit of innocence. I'm going to appoint you an attorney. I want some more information about these two theft convictions. Are you still on post-release control?
No, I successfully completed it.
I don't know about successfully. Having new convictions is not successfully completing that. All right, at this point, the court is going to find that you're indigent for the purposes of retaining counsel. I will appoint Attorney John Helbling to represent you in this matter. There is probable cause that you have violated the terms of your community control. I'm going to set this for a final hearing. Why should you remain free on bond pending this probation violation?
Well, I'm in a program.
Well, you've been in the program and you got a theft conviction, right?
I wasn't.
All right. Get a hold of Mr. Helbling.
Okay.
I'll let you stay out for now. That's all. Jack, what do you? This is case number 23CR40094, the State of Ohio versus William Hupp. Mr. Hupp is before the court at the request of his probation officer for termination. Ms. Tranter, has the victim been notified?
Yes, Your Honor.
And does the state have a position?
Yes, Your Honor, the state is going to strenuously object to Mr. Huff being early termed. I don't normally object to these. However, I think in this case it's appropriate. This is a judicial release. You had sent Mr. Huff to prison, gave him a break by letting him out. I think this is a violent offense. His record is not great. And due to the nature of the offense, I don't think he should be rewarded yet again with an early termination. I think it would be a good idea for Officer Henry to keep an eye on him for the remainder of his term on probation and give him a little more incentive to try to abide by the law.
Did the victim have a position on this?
Your Honor, the victim wishes to remain silent.
Mr. Hupp, tell me about what happened back in May of this year when you got charged or arrested with violation of a protection order.
So, ultimately, it's my fault.
Was this with this victim?
Yes, Your Honor.
All right, I'm denying it. That's too close in time to today. I mean, the orders are the orders, and I understand that you've done very well.
Yeah.
And while I don't want to continue to punish you, I do believe that the orders need to remain in effect for now because of that incident.
Yeah,
Okay.
I understand. Can I take 30 seconds to explain?
Sure.
Not as an excuse, but simply as
Were
an
you
explanation.
convicted of that?
What's that?
Were you convicted of that?
No.
It
no,
was
Your Honor.
dropped.
It was dropped.
Okay.
So-
Did she drop the protection order too now, or is it still in
Yes.
effect?
Yes.
But you still have a no contact order from me?
Yes.
Okay.
So basically, and again, it's my fault, but it was simply confusion. It was a misunderstanding. So I came in for a visit. Officer Henry was not here. He had just left. I was going to meet with someone new for the very first time. 5 minutes before I'm leaving to come to that visit, I smashed my hand and exploded my pinky finger. It split it like a snake's tongue. I wasn't going to miss the appointment. I couldn't get a hold of anybody on the phone. I came here anyway, and what I was trying to get was an answer as to whether or not all that stuff was done. So standing in the waiting room for probation, they finally found the person that I was supposed to see because I didn't even know who it was. And they were more worried about my hand, which I probably should have been. But I was asking if everything else was done, that it was okay. And the answer that I got was yes, but not exactly in the context of what I was asking. There was a lot of confusion because of what was
You
going
were
on with
asking
my
whether
finger.
the order was still in effect, and they're
Yes.
looking at, have you complied with all the other orders? And they're telling you yes, and you're taking that the
Exactly.
All right.
That was Thursday. Friday or Saturday was when this incident happened. Got traffic stopped for a roadside sobriety checkpoint kind of thing. So it's just completely at random. Wasn't violating any traffic laws, wasn't
she
doing
was with
anything.
you?
Yes. So, and then and then it was trying to find out after the fact why there was still something in the system when I was under the belief that there was
She dropped the
nothing.
protection order, but my no contact order was still in existence.
Exactly. So it was a misunderstanding, and again, it was my fault, but it was a misunderstanding. I didn't violate it intentionally, knowing that I was violating it.
Okay.
I would have never.
Are you and her plan on re-engaging in a relationship?
Ultimately, we've reverted back to no contact with each other because of this. So
If she wants, look, if she wants, I know that she wants to stay out of this to some extent, and for whatever reason she has, if she wants me to drop the no contact order, I have to have her come in. Does that make sense?
I'm pretty sure that I know where she stands on it, but at the same time, yeah, she does not want to be a part of any proceeding. So when this all originally happened, originally she had wrote a letter, which then ended up not coming into play. I don't expect you to remember that. It's been quite some time ago now. But then that letter didn't end up showing up until after the sentencing had already taken place.
I see.
But yeah, as far as her coming in, she doesn't have any desire to be here.
It looks like yeah, it actually looks like her letter must have come in the same day, but after I sentenced you. That's what it looks like here.
Okay.
So, Mr. Officer Henry, you don't have him doing anything else right now, correct?
At this current moment, no, Your Honor. My recommendation when I re-notified you of everything that had proceeded from his original termination hearing to the arrest to where that charge had gone, I had two recommendations. One was to proceed with this termination hearing, but if there were still concerns regarding this contact order, it was to push him onto a non-reporting status for the remainder of his time on supervision. And if there would be any issues further with this victim, we could address it further in court.
All right, I'm inclined to do that at this point. I mean, if, perhaps if Miss Rutherford was here, I might feel differently, but since she's not, and understand her position as well, so I'm not going to take a chance at this point. I'll allow our Officer Henry to continue to supervise you if he wants to do that on a non-reporting basis for now. But the no contact order is still in place until I hear from her.
I understand.
All right, very good. Good luck.
Thank you, Your Honor.
Yep. I'll call you in a little bit later.
Thanks.
It's rebuttably presumed you would be released from service of the sentence on the expiration of the 3-year sentence, or any presumptive earned release date. But in this case, if it's mandatory time, there is no early release date or good time date on that. The Department of Corrections may rebut the presumption if at a hearing under section 2967.271 of the revised code, the department makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. If the department at the hearing makes the specific determination and rebuts the presumption, the department may maintain your incarceration after expiration of that 3 years or for a length of time the department determines to be reasonable, subject to the limitation that requires your release at the end of the 4.5 years. The department may make specific determinations and maintain your incarceration under the provisions previously described more than one time, subject to the limitation specified that requires your release no later than the end of the 4.5 years. If you've not been released prior to the expiration of the 4.5 years, then you must be released upon the expiration of that term. Do you have any questions about your constitutional rights?
No.
Do you have any questions about post-release control?
No.
Do you feel you understood this indeterminate sentence explanation?
Yeah.
I find this to be a knowing and voluntary waiver of constitutional rights. What is your plea to count 1?
Guilty.
That would be illegal conveyance of drugs of abuse onto the grounds of the specified government facility. What is your plea to aggravated trafficking in drugs in count 2?
Guilty.
What is your plea to aggravated possession of drugs in count 3?
Guilty.
What is your plea to aggravated trafficking in drugs in count 4?
Guilty.
What is your plea to aggravated possession of drugs in count 5?
Guilty.
What is your plea to possessing criminal tools in count 6?
Guilty.
What is your plea to engaging in a pattern of corrupt activity in count 8?
Guilty.
All right, accept your plea, make a finding of guilty. Mr. Oswald, do you want to proceed with sentencing today?
Yes, Your Honor, waive PSI.
Okay. Anything from the state on sentencing?
Judge, I would first indicate that counts 2 and 3 and counts 4 and 5 would be allied offenses of similar import. So the state is choosing to proceed on count 2 and count 4, with counts 3 and 5 merging into counts 2 and 4. Beyond that, Judge, as you understand from our conversation, the reason why the state is proceeding in this fashion is honestly because of the defendant's current prison sentence. He's in prison on an aggravated murder charge. His earliest parole date is 2061. So this is adding some time to that ultimate parole date. But that's really the motivation for going forward in this fashion. So having said that, as we mentioned back in chambers, we do not have any objection to what the court indicated it would do. And I did speak with the investigating trooper on this, and he feels the same way.
All right, thank you. Mr. Oswald, anything on behalf of Mr. Lewis?
Your Honor, as you heard from the prosecutor, Mr. Lewis's out date is 2061. In this case, he did accept responsibility. Many times when inmates have that far of an out date, they tend to go to trial just to play games. In this case, that is not happening. Mr. Lewis stepped up, he accepted responsibilities for his actions. Since his out date is 2061, we would ask that you find him indigent for any court costs and fines, and also waive the mandatory fines and impose the 3 to 4.5 year sentence.
Okay, thank you. Mr. Lewis, is there anything you want to say, sir? No. Okay. On count 1, the sentence is 24 months. On count 2, the sentence is 4 years. On count 3, the sentence is 4 years. But count 3 merges with count 2. On count 4, the sentence is 4 years, is 36 months. On count 5, the sentence is 36 months. Count 5 merges with count 4. On count 6, the sentence is 12 months. On count 8, the sentence is 3 to 4.5 years. Counts 1, 2, 3, 5, 6, and 8 are to run concurrent. I stated that.
Judge, I think that possibly on count 2, you said a little bit incorrectly what you were trying to say. On count 6, count 8, you indicated the sentence was 3 years to 4.5 years. That's your indeterminate sentence on count 8. Count 2 is the only other charge with an indeterminate sentence. You said 4 years, and I believe you meant to say 3 to 4.5.
You're right.
Which would match count 8. And then it would be counts 1, 2, 4, 6, and 8 that would run concurrent to each other. Does that sound correct?
1, 2, 4, 6, and 8 run
Correct.
concurrent.
Because the other two merge. Yes, sir.
Yeah,
yes,
by sentencing him to 4 years, that would exceed the one in count 8.
Correct. So both 2 and 8 should say 3 years to 4.5 years using the indeterminate sentence.
Sounds right. Okay.
And Judge, is that being ordered to be served consecutive to the current term that he is serving?
Yes.
Okay.
The basis for the consecutive sentence is to protect the public, to also be a deterrent to any future crime, and it's not disproportionate to the sentence as well.
And Judge, you're waiving fees and costs?
Waive fees and costs.
And I believe.
Fines and costs,
Yes,
fines,
sir.
fees, and costs.
And then I believe he would, because he's been in prison, he has 0 days of jail time credit.
Okay, no credit.
And I believe that's it, Judge, unless defense has anything else.
Nothing further.
Mr. Oswald, do you have any questions, sir?
No.
Okay, you have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. That's all. Thank you.
Thank you, Judge.
Sorry, late, I was here in conference last week, so I didn't call that sooner, but,
I wasn't trying to make him feel bad. I was just letting you know.
we represent Mr. Lopez on a VOP that's based upon him being, dismissed from drug court. And it's my understanding that as a result of him being dismissed from drug court, that creates a conflict of interest for our office. And so I think
I
that.
still understand why that is the case, but I also understand that that's the position that your office takes due to the fact that you have members of your office that are on the board, something on that order.
Yes, Judge.
All right, I will allow you to withdraw. Mr. Lopez, I'm going to need to appoint you another lawyer, and looking to my right, the only lawyer that I can see that's local enough that I can appoint would be Mr. Mark Atchison. Mr. Atchison, you mind taking this appointment for Mr. Portillo Lopez Jr.
I don't see why not, Judge.
Thank you, Judge.
It's a probation violation, so we will give you an opportunity by setting it to November the 28th, so that you can work out. 25th, November 25th.
Judge, I've got an order. I can tell you.
Thank you, Judge.
We go back to page 1, document number 15130, State versus Roy Thomas Farm Street. Farm Street, you're here today to be arraigned on an indictment charging you with 25 different counts, including money laundering, manufacturing, and possession of methamphetamine with intent to sell, distribute, possession of Schedule II drug, fentanyl, theft of a firearm, possession of a weapon by convicted felon, aggravated assault on law enforcement officer, possession of firearm with intent to go armed, and multiple other counts. You have the right to an attorney. You wish to have a lawyer represent you?
Yes.
All right, Mr. Hooper, Judge Simpson.
Before reading the indictment, they were pleading not to motion, Your Honor.
All right, plead not guilty as entered. General?
Matter November the 12th for status. So we're trying to trial date to be.
November 12th for status. Mr. Hooper with the Public Defender's Office can talk to you and get you ready for the next step in your case. Thank you. All right, going back into page 8, we're move that so that he can move it. Thank you. All right, document 1549, State versus Harold Maurice Marsh. Mr. Marsh, you are here to be arraigned on an indictment charging you with resisting arrest, resisting a stop, arrest, or search, and criminal trespass and disorderly conduct. You have the right to an attorney. Do you wish to have a lawyer represent you?
Proceed.
You want to represent yourself on this matter?
Yes, sir.
All right, you understand that if you represent, you have every right to represent yourself without any question. The Constitution gives everyone that right. But you understand that you would be held to the same standard as a person who has been trained in the law and who has a law degree.
Yes, sir.
Have you familiarized yourself with the rules of criminal procedure?
Pretty much so, yes, sir.
Have you familiarized yourself with the rules of evidence?
Yeah, but I'm trying to get the evidence, but city police keep on putting up roadblocks, so I can't get my evidence.
Okay, well, there's a difference between getting your evidence and see, there are certain rules. And as a judge, the judge who hears your case has to enforce the rules of evidence, which means only certain material can come into a courtroom under our rules of evidence. So the question is just a matter of whether or not you feel like you are competent to represent yourself. How far did you go in school?
I dropped out in 10th grade.
10th grade, right. But do you understand what you're asking the court to allow you to do?
Yes, sir.
And you understand you're waiving your right to an attorney in order to do that?
Yes, sir.
To show that he has waived his right to an attorney. Mr. Marsh, I am here to arraign you. Do you wish me to read this indictment to you in open court, or do you want to waive that formal reading and read it yourself?
I'd like you to read it in court, please, sir.
In the circuit court for Humphreys County, Clingman waiver on the October term of the grand jury 2025. Grand jurors of Humphreys County, Tennessee, newly elected and panel is sworn, do find that on or about April the 20th, 2025 in Humphreys County, Tennessee, Harold Maurice Marsh did unlawfully and intentionally prevent or obstruct a law enforcement officer, Corey Field, with the Waverly Police Department from effecting a stop, frisk, halt, arrest in violation of Tennessee Code Annotated 39-16-602, a Class B misdemeanor, all of which is against the peace and dignity of the state of Tennessee. Count 2, and the grand jurors do find that on or about April the 20th, 2025 in Humphreys County, Tennessee, Harold Maurice Marsh did unlawfully enter or remain on the property of the Waverly Church of Nazarene without the owner's consent to do so, in violation of Tennessee Code Annotated 39-14-405, a Class C misdemeanor, all of which is against the peace and dignity of the state of Tennessee. Count 3, and the grand jurors do find that on or about April 20th, 2025, in Humphreys County, Tennessee, Harold Maurice Marsh is unlawfully in a public place with the intent to cause public annoyance or alarm, cause a disturbance by being loud and disruptive and making unreasonable noise which prevented others from carrying on lawful activities in violation of Tennessee Code Annotated 39-17-305, a Class C misdemeanor, all of which is against the peace and dignity of the state of Tennessee, signed W.A. Crouch Jr., District Attorney General. So the defendant has been arraigned. How do you wish to plead to that indictment, Mr. Marsh?
Innocent on all charges.
Pardon?
Innocent on all charges.
Oh. I have a form that you will need to sign that shows that you have been advised of your rights and that you're waiving your right to an attorney. You'll sign that form for me, please. Officer Dillon, you'll retrieve that document, a copy of that indictment for me, please. Just hand her back that indictment. I need to put some dates on there for you.
Okay.
What are we doing date-wise?
Yes, sir. April the 14th for a final plea day, April the 22nd.
Right, you're representing yourself, Mr. Marsh, so your last day to discuss a negotiated plea with the district attorney's office will be April the 14th of 2026. Then you will be put to trial if you do not resolve your case on April the 22nd of 2026. All right? Thank you, and good luck to you.
Thank you, sir.
Docket number 15150, State versus Alicia Carol Matheny. Matheny, you appear to be arraigned on an indictment charging you with rape of a child and incest. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
White Palmer, and documents here, plea of not guilty.
Plea of not guilty is entered.
November the 12th, please.
November the 12th in status. Lawyer will be up to talk with you and see if he can get you ready for either a resolution or a trial. Okay? All right, thank you. Docket number 1515. Docket number 15151. State versus Perez DeMarcus Miley. Miley, you are here to be arraigned on an indictment charging with assault on a first offender, on a first responder. You have 2 counts of assault on a law enforcement officer. You have the right to an attorney. Do you wish to have a lawyer represent you? You want a public defender?
Yes, sir. Represented previously, Your Honor.
All right, Mr. Hooper, the public defender is here, and I'm appointing the public defender to represent you.
White Palmer, reading the indictment, enter a plea of not guilty.
Plea of not guilty is entered.
November the 12th.
November 12th, the status. Public defender will be up to talk with you as soon as possible. Docket number 15152, State versus Lawrence Bradley Nix.
Judge, Mr. Spratt represents Mr. Nix.
Hey, Judge, I'm standing in for Mr. Spratt. I believe he filed a waiver.
All right, show Mr. Spratt as the attorney of record for the defendant. Plea of not guilty is entered. Dates, General.
Your Honor, April the 14th for plea, April the 23rd for trial.
All right. Docket number 15153, State versus Marvin W. Northington. Marvin W. Northington.
Mr. Irving, since you had the bond advisor's findings for $4,000.
Be a conditional forfeiture of the bond in the amount of $4,000. Citation of the bonding company set the final forfeiture on that date 6 months down the road. Interest for the defendant's arrest. New bond will be $10,000.
Yes.
Docket number 14803, State of Tennessee versus Michael Brandon Odom.
Judge, the TPMC, we sent an order for them to be on Zoom. You know, the way they're actually,
Yeah, we're working on getting him out. I do apologize for the.
All right. Then if you'll let Ms. McKinney know that you're ready as soon as possible, and we'll come back to you, okay, as soon as he's available.
Yes, sir. He's still in his cell. We're getting him out now. We just had some issues this morning, but we're running a little behind. I do apologize.
That's all right. As soon as you're ready, let us know, and we'll just notify, send us a message on the chat on Zoom, and we'll bring you back in. Okay?
Yes, sir. Thank you.
Thank you. And at the jail, we're looking at docket number 15155A, State versus Tabitha Sue Patterson. Ms. Patterson, you're here to be arraigned on a charge of child abuse, neglect, or endangerment, and you have the right to an attorney. Do you wish to have a lawyer represent you?
Sir.
All right, public defender. Co-defendant is shown to be Cody Tabor.
We represent Mr. Tepe, Your Honor.
All right. Right. I'm going to appoint Mr. Lee Spratt to represent you in this.
Is there any reduction? Anyway, ask for a bond reduction?
Well, I've got to give you a lawyer first, and then your lawyer can meet with you and file a motion for a bond reduction. But you will, since you have to have a lawyer, you will need to have that lawyer present for a hearing on a bond reduction. Bond reductions don't occur automatically, but require a hearing where both sides get to present evidence. So now that you have a lawyer, you need to have Mr. Spratt file that motion to get it heard as soon as possible.
Okay.
All right. Thank you.
Okay, thanks.
Oh, you need a date.
November 12th.
November 12th. Mr. Hooper, standing in for Mr. Spratt, do you wish a formal reading of the hearing? Ms. Patterson, come back to the docket if you will. Ms. Patterson, can you come back? Ms. Patterson, I'll just arrange it up.
Sorry.
I need to arraign you, and this indictment says that in the Circuit Court of Humphreys County, Tennessee, at Waverly, October term of the grand jury in 2025. The grand jurors of Humphreys County, Tennessee, duly elected panel and sworn to be found in honor about August 8th of 2025 in Humphreys County, Tennessee. Tabitha Sue Patterson and Cody Wade Taylor did unlawfully and feloniously expose WPT, a child under the age of 8 years or less, to methamphetamine or any other controlled substance in violation of Tennessee Code Annotated 3950-401, a Class B felony, all of which is against the peace and dignity of the state of Tennessee. W. Ray Crouch, Jr., District Attorney General. Show that she has been arraigned. That will be given to Mr. Spratt. Please not get considered. We're going to set this for November the 12th. Is that correct?
Yes, sir, Your Honor.
November 12th. All right, Mr. Spratt will be in touch with you as soon as he's notified. Thank you. Docket number 15158B, State versus Cassie M. Plunkett. Ms. Plunkett, you are here to be arraigned on a multi-count indictment charging you with child abuse, neglect, and endangerment of a child 8 years or less, and multiple counts of child abuse, neglect, and endangerment, and cruelty to animals. You have the right to an attorney. Do you wish to have a lawyer?
Yes.
Are you able to hire a lawyer? Raise your right hand. Take your oath.
You solemnly swear or affirm that the testimony I give shall be the truth, whole truth, and nothing but the truth, so help you God.
You're going to have to fill out this affidavit of your income and expenses to be determined whether or not you qualify to have an attorney appointed. I will come back to you later in the day to determine whether or not you qualify. Docket number 15156, State versus Rodney W. Priest. Priest, you're here to be arraigned on an indictment charging you with forgery, altering or falsifying and forging a title or plate or assignment, and making a false report to a police officer. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Are you planning on hiring a lawyer? General, what dates are we assigning?
November the 12th.
All right, your next date will be November the 12th, and that will be for your status as to hiring a lawyer. So do your best to hire a lawyer and have that lawyer with you here on November the 12th. All right, moving to page 11. Docket number 14956, State versus Nick Ryan Russell.
John has this agent bring him over.
All right, we're going to call a second call and bring him over. Docket number 15129C, State versus Marissa Dawn Smith. Ms. Smith, you're here to be.
This is Mr. Perez.
The next one.
Is it Leas?
Lees.
Lees,
Okay.
L-E-Y-E-S.
All right, this is case number 25CR 42990, State of Ohio versus Philip Lees. Mr. Lees is present with his attorney Connor Riley. State is represented by Brian Goodyear. We're here for a hearing on a request to drop a temporary protection order. Do you have any one you want to call on that case, Mr. Goodyear?
Well, Judge, this is a motion filed by Ms. Moffett, so I think really I would like to be heard at some point regarding the motion, but I think it's really up to her how she wants to proceed.
Yeah, the question is who goes forward.
I would think that, considering this is a motion I do not support, I would think that she would be the one that should go forward.
Okay. Ma'am, do you want to come up? Good afternoon.
Good afternoon. My name's Jennifer Moffett, for the record. I have written a motion to drop the temporary protection order that Philip Lees has on him. We've had no contact since any incident. I don't feel that there's any sort of danger to myself or my family. I work in the community that he lives in. I know, I guess I don't know, but I can only assume that's caused him issues. It's caused me issues because I have to detour around the house I'm trying not to offset his whatever tracker, whatever happens there. I just think for the sake of everybody being able to move forward, that it be removed.
Who requested this?
I did.
Okay. Are you two married?
We are not.
Okay. Do you mind telling me what the relationship is?
We were boyfriend, girlfriend.
Okay. And you requested a
And
protection?
we were living together.
Okay.
Prior to this event.
Now you're not?
I moved out.
You moved out?
Yes.
Okay. Why did you request the protection order?
I did not. The state did it automatically.
Okay, I thought I asked the question, who requested it? You said.
Oh, I'm sorry. I thought you asked me, why did I request it? It was placed on him automatically, I guess, at his bail hearing.
Okay. All right.
Is my
Fair enough.
understanding.
Okay. And you think that was an improper move?
I do.
Okay. Anything, Mr. Goodyear?
Judge, I would just say, we have a felony 3 domestic violence charge, and part of the evidence in this case is her daughter was present in the home when an argument ensued. Her daughter actually she was videotaping with her phone. She wasn't in the same room. So really you hear an argument, you hear her get smacked, and then the police come and see that she's got a handprint on her face. And again, this all happened with her daughter in the same home. And the concern I have, Judge, is from my perspective, when a case like this is pending, to allow the parties to have contact just increases the chances of problems occurring and frankly other violations occurring. And if it were me, if there's one person in the world that should not be okay with this, it's Mr.
Lees.
Lees. Because if they have contact, who knows what's going to happen? So I've always felt like, Judge, in cases like this, it's best to maintain the status quo. It's best to keep a protection order in place so they do not have contact until the matter is resolved, to make sure that all parties don't create additional problems while the case is pending.
All right, thank you. Mr. Riley, do you want to add anything to that?
If I may, Your Honor. The request from Ms. Moffett is to drop the temporary protection order. The protection order that she did not request at any point be imposed on Mr. Lees. This court, if it does honor Ms. Moffitt's wish to drop the temporary protection order, it could still put contact restrictions as a condition of Mr. Lee's bond, just outside the confines of the protection order. I'll note for the court's benefit that the two parties no longer live together. They have broken up. They're no longer in a romantic relationship. If this court grants Ms. Moffitt's request, it's not like they're going to be living together. They live separate and apart. But the protection order should be in place for the alleged victim's benefit. Ms. Moffitt has made it very clear she never requested it. She thinks it's improper. She doesn't want it, that it's not granting her any benefit whatsoever, and in fact, it's causing her a hardship. Your Honor, I don't want to get into the allegations or the details of this case at this point. I don't think this is the time for it, but I will just note that I would dispute some of the assertions made by the state in this case. I'll also note that the reason we're here in felony court on a felony domestic violence is, and please correct me, Mr. Goodyear, if I'm wrong, is for 2 misdemeanor convictions from over 20 years ago that had nothing to do with Ms. Moffitt. There is no prior cases between Ms. Moffitt and Mr. Lees. Again, given that they have broken up, do not live together, or frankly anywhere close to each other, we would join Ms. Moffitt in her request. And again, pursuant to Marcy's law, this is her request. The TPO would be for her benefit. She's asking for it to be removed. I'd ask the court to grant her motion.
All right, thank you. Ms. Moffitt, has anyone contacted you to try to convince you to do this?
No, sir.
Okay, do you feel you're under any distress or anything of that nature?
To make the motion, you mean?
Right.
No, sir.
Okay. Anything from the victim's advocate as to whether or not you observe any thing that's concerning?
No, Your Honor, actually, when the case was in lower court, I know she made the similar request in lower court. It was slightly modified at that time, but it was not completely terminated. And she's asserted the same request throughout the indictment process and arraignment until we're here. So I think she's been pretty consistent in that request.
Okay. Well, she's an adult. She appears to be under no distress or pressure. She's not wanted this from the beginning. People have to live their lives. I'm going to grant a request to remove the protection order.
Thank you.
Okay, that's all.
Your Honor, if I may?
Yes.
Very briefly. We're here today. This hearing is for a very specific limited purpose. It's on Ms. Moffitt's motion. And the first pretrial in this case before you is not set till November 12th. Given that Ms. Moffitt is here, a condition of Mr. Lee's bond is currently electronic monitoring. I was planning on addressing that on November 12th at the first pretrial on this case, but given that Ms. Moffitt is in the courtroom and that pursuant to Marcy's law, she could have input on that request, would the court allow me to make that motion to remove electronic monitoring today, or would the court prefer me to make that motion on November 12th?
You can make the oral motion.
Thank you very much, Your Honor. At this time, we are requesting that the electronic monitoring house arrest portion of Mr. Lee's bond be removed. He works a blue-collar job. He travels a lot to different various locations to do his work. And the monitor, while he does have extremely broad hours and he is able to work with it, it's just very uncomfortable. He's been on it for, you were arrested when? He's been on it for 2 months without any violation. And I'm asking the court to consider removing it. He did post a significant monetary bond, which will ensure his appearance at all court dates. I would ask the court to inquire as to Ms. Moffitt's position, if she would like him to remain on the electronic monitoring, or if she would be okay with that being removed as a condition of his bond. And lastly, Your Honor, I'll just note that it has been many, many, many years since Mr. Lees has been criminally charged with anything like this. He's a full-time working, hard-working citizen, and he has made every single court date, will continue to do so. He's not a flight risk or the danger to the community. I'd ask the court to take that all into consideration. Thank you.
All right, anything from the state?
Judge, whether or not the victim wants him to be on electronic monitor, I think that it's still appropriate as a condition of his bond for him to be on electronic monitor. It's obviously not keeping him from working, and it's not having any impact on all the things that were described as an inconvenience. But from the state's perspective, Judge, again, sometimes we have to protect people from themselves. And I think that in a domestic violence case, whether or not the two convictions were from 5 minutes ago or 25 years ago, he has two convictions for domestic violence. And again, he has now an indictment for a felony 3. He posted what I assume to be $5,000 for his bond, because his bond was $50,000 at 10%. So he posted a $5,000 bond, but that doesn't do anything to keep him from getting angry again and doing something that would cause injury to someone else. So I think that you've not heard anything here about any major problem with him being on EMU other than he just doesn't like it. I think it's an additional layer of safety regardless of whether the victim wants it or not, and we think it should remain.
Okay. I've considered more than just whether or not he'll appear in court. I've considered other factors, including protection of the public, protection of the victim. However, he's been on since August of 25. He's been on almost 2 months with no problem. No history that I'm aware of in the past 20 years. So I'll grant the motion to remove the monitor.
Thank you very much, Your Honor.
Yes, sir. Now, we still have a pretrial set.
November 12th. Yes, Your
November 12th. Do you want to wait to do the pretrial or do that now? The issue is going to be, where are we going with this case?
Understood. Your Honor, I received discovery from the state. I would ask to keep the hearing on the 12th, because
Okay.
I think at that time I can give the court a good indication. Am I requesting another pretrial? Am I ready to set it for trial? Whatever it may be, I think I'll be better prepared to answer that question on the 12th than today.
Okay. We'll see you then.
Thank you very much, Your Honor.
Thank you, Judge.
Yes, sir.